For the inaugural session named Intellectual Property Rights in the Seed Sector, Importance and Policy Priorities, I would like to request our dignitaries to kindly grace their presence on the dais, please. Mr. Rajveer Rathi, Vice Chairman FSII, Head Agricultural Policy and Stakeholder Affairs, Bayer Crop Science. Mr. Ajay Rana, Chairman FSII, Managing Director and CEO, Savannah Seeds. Dr. Yogesh Pai, Associate Professor Law, in charge of DPIIT IPR Chair and Co-Director, Center for Innovation, IP and Competition, National Law University, Delhi. Padma Bhushan, Dr. R.S. Baroda, Founder Chairman, Trust of Advancement of Agricultural Sciences. Dr. Trilochan Mahapatra, Chairperson, Protection of Plant Varieties and Farmers' Rights Authority, PPVFRA, Government of India. Mr. Raghavan Sampath Kumar, Executive Director at the Federation of Seed Industry of India. Eminent dignitaries on the dais, special invitees, distinguished representatives, and stakeholders from center and state governments, law and research institutes, seed industry, agri mechanization, crop care, government procurement policymakers, and implementing agencies. Ladies and gentlemen, a very warm welcome to the inaugural session of the Federation of Seed Industry of India Conference Innovate, Protect, Prosper Role of Intellectual Property Protection in Taking India's Seed Sector to the Next Level. This conference aims to explore fair access to genetic resources, robust IP protection, and efficient technology transfer. Professionals from diverse sectors will convene to navigate complex regulations, fostering innovations while ensuring equitable access. Ladies and gentlemen, we are honored to have with us today Padma Bhushan Dr. R.S. Baroda, Founder Chairman, Trust of Advancement of Agricultural Sciences, and other eminent dignitaries. May I now request Mr. Rajveer Rathi to do the honors of welcoming our session chair, Dr. R.S. Baroda, with a small token of appreciation, please. Dr. R.S. Baroda is a distinguished scientist and research administrator, recognized with the Padma Bhushan for modernizing India's agricultural research system. He has received numerous awards, including the Norman E. Bolrock Award and M.S. Swaminathan Award. Dr. Baroda has served in leadership roles globally, founding the Global Forum on Agriculture Research and contributing to agricultural development initiatives across Asia Pacific. Thank you so much, sir. We are honored to have with us today Dr. Trilochan Mahapatra, Chairperson, Protection of Plant Varieties and Farmers' Rights Authority, PPVFRA, Government of India. May I please request Mr. Ajay Rana to do the honors of welcoming our Chief Guest, Dr. Trilochan Mahapatra, with a small token of appreciation, please. With over 30 years in agricultural research and education, Dr. Mahapatra has significantly contributed to increasing India's pulses and sugar production as the former Director General of ICAR and Secretary of DARE. Dr. Mahapatra's pioneering work includes decoding genomes and developing high yield crop varieties. A distinguished scientist with numerous awards, he has published extensively and is a fellow of several prestigious academies. Thank you so much, sir. We have with us Dr. Yogesh Pai, Associate Professor Law in charge of DPIIT IPR Chair and Co-Director, Center for Innovation, IP and Competition, National Law University, Delhi. May I please request Mr. Kuldeep Tyagi to do the honors of welcoming our special guest, Dr. Yogesh Pai, with a small token of appreciation. Dr. Yogesh Pai is a distinguished scholar specializing in intellectual property law with a keen focus on its intersection with competition, trade, and economic policy. As a Thomas Edison Fellow and current scholar in CIP2, George Mason University, he brings extensive expertise cultivated through roles at institutions like the World Trade Organization and the WIPO Academy. Dr. Pai's leadership as co-director of CIPC at National Law University, Delhi, underscores his commitment to advancement, IP education, and research globally. Thank you so much, sir. Ladies and gentlemen, welcome once again. As a leading association representing 40 members in the R&D based plant science industry, we at the Federation of Seed Industry of India are committed to producing top quality seeds crucial for the nation's food, feed and fiber sectors. Today, we gather to explore equitable access to genetic resources, reinforce IP protection and streamline technology transfer. With participation from professionals across sectors, let's navigate regulatory frameworks and promote inclusive practices for sustainable industry growth. Thank you for joining us. May I now invite Mr. Rajveer Rathi, Head Public Affairs, Science and Sustainability, Lead Trades Licensing Business at Bayer Crop Science, to kindly begin the proceedings with his opening remarks and context setting. Okay. Okay. Ladies and gentlemen, and our esteemed guests, we gather here today to mark the beginning of our special event with the auspicious ceremony of lighting the ceremonial lamp, symbolizing the light of knowledge that guide us in the pursuit of medical excellence. May I now request Honorable Chief Guest and eminent dignitaries on the dais to kindly light the ceremonial lamp and formally inaugurate the conference. Thank you to our esteemed guests, dignitaries, for illuminating our path forward. Thank you. I can also skip. Huh? Okay. Okay.
Good morning, everyone. Honorable Chair for the session today, Padam Bhushan Dr. R.S. Paroda, Chairman PPUFRA Dr. Mahapatra, other colleagues on the dais, and senior, colleagues in the audience and industry colleagues. And we just celebrated the International, IPR Day on 26th of April, so we are very close to that occasion, and I think the time is very apt. And I've been given the task to give opening remarks in context setting. But if I look at the people on the dais and then the people in the room, I think it's more than hundreds of years of collective wisdom and experience which is over there. But still, just to uh, put a few things to reiterate because it's really important. From the point of seed and biotech, we all know that they are the strong pillar for production, prosperity, and the food security at large. And to make it happen on regular basis, I think the one part, the protection, the intellectual property, is the crucial one, just to ensure that the inventors stay committed, new technologies become accessible to the farmers, to the researchers, to the end user industry, and which contribute significantly to the nation as a whole. If I may not be wrong, if I can say since 1992 until today, I think we have seen a lot of, uh, at an international level and also at a domestic level in terms of whether it's in CBD, whether it's an improvement in the intellectual property. WIPO is coming up, and India is not far behind. If you look at, they had enacted PPFRA, they have revised the Patent Act in 2005 uh, to ensure that India remains compliant because it's majorly the agriculture economy, not just from the export point of view, but also for the domestic consumption, and that's where the innovation is essentially needed. And to make sure that innovation pipeline runs continuously, and that's where the IP plays an important role. So I want to just close by saying the three things, like during the day, that why IPR, why it is important. We all know about it, but let's dwell on that. And why IPR in seed and biotech now. Today, if you look at not just the climate change, but the human activities, be it the conflict, which we have seen, not to mention about it, it also indirectly contributing to that. We have seen 2 years back that how the world food supply disruption has happened, and that's where the role of IP to protect the innovation becomes really, really important. But at the same time, if you look at the other aspect of IP, having rules and regulation is one part, but unless we have a robust, predictable, the enforcement mechanism, and there are a lot of deliberations which has happened, like when we go and meet Dr. Mahapatra, he's very open that, okay, industry should come forward, that how collectively we can work together so that besides having rules and regulations, how we can have the enforcement mechanism, right? So that the innovators stay motivated, farmer get the right kind of variety or what is there on the label, he pays for that. And definitely it's translate into what he's producing, he gets for that and paid for that, So with that, again, welcome everyone and thank you so much.
Thank you so much, sir. As sir rightly said, talking about seed industry's perspective on the role of intellectual property protection in taking India's seed sector to the next level, what we learn is that in the Indian seed industry, intellectual property protection is paramount of driving innovation and attracting investment in research and development. Strong IP rights not only secure market access but also foster sustainability and facilitate technology transfer, enabling global collaborations. Strengthening our IP framework is the key to propelling India's seed sector to the international competitiveness and ensuring a sustainable future for agriculture. May I now invite Mr. Ajay Rana, Chairman FSII, Managing Director and CEO, Savannah Seeds, for the welcome address, please.
Good morning. Manchasin, Dr. R.S. Paroda, uh, Dr. Trilochan Mahapatra, Dr. Yogesh Pai, my industry colleague Rajveer, Raghavan, uh, all the industry colleagues, academic, scientists, and I can see some students also, and colleagues from media. Good morning once again. बहुत ही relevant topic है intellectual property rights for seed industry as well as the gross domestic product GDP of any country. हम IPR intellectual property right जब हम इंग्लिश में बोलते हैं तो बहुत फॉरेन वर्ड लगता है और इसको हिंदी में बोलेंगे बौद्धिक संपदा का अधिकार तो लगता है कि हमारी चीज है कुछ। मैं कल राघवन से बात किया कि भाई किस बारे में बात करना है, इन्होंने ही गेव मी सम टॉपिक्स, लेकिन मैंने फिर मेरे पिताजी हिंदी के टीचर थे और मैं बोला हिंदी में इंटेलेक्चुअल प्रॉपर्टी बोलते हैं तो ऐसा लगता है बिल्कुल अपनी चीज है, बौद्धिक संपदा, और बौद्धिक संपदा का अधिकार सबका अधिकार है। इंटेलेक्चुअल प्रॉपर्टी राइट हम बोलते हैं तो लगता है कि ये वेस्टर्न वर्ल्ड, विदेशियों ने कोई टर्म बनाई है और ये हमसे कुछ छीनने के लिए बनाई है। बिल्कुल ऐसा नहीं है। हमारी हजारों साल पुरानी संस्कृति है। हम पुराने आविष्कार देखें, हमारे वेद पढ़ें, पुराण पढ़ें, जो चरक है हमारा मेडिसिन के पुराने जितने भी लिटरेचर है, इंडिया हैज बीन हिस्टोरिकली एन इनोवेटर, बट लाइक देयर इज ए टाइम हैज ए साइकिल, वो चक्र घूमता है, चक्र घूमा, हम कभी विकसित थे, बीच में हम लोग एक 700-800 साल का ऐसा चक्र घूमा, और बाद में जब ब्रिटिशर्स यहाँ पे थे तो चक्र ऐसा घुमा कि हमारा जो इनोवेशन था और जो हमारी स्मॉल स्केल इंडस्ट्रीज थी, इनफैक्ट लाइक ऑल दैट वर systematically destroyed. And same time, there was an industrial revolution happening in the West. So they were like, I think it was done with a purpose, and it was done very systematically. I have no shame in talking about it. Even I work for a multinational, but this is fact. So, but now the chakra is here again in Asia, especially India and China. This is our time. We no longer have to be worried about ईस्ट इंडिया कंपनी आएगा, वो देश से कुछ लेके जाएगा। हमारी खुद की कंपनियां अब बाहर जा रही हैं। You look at IT sector. How many employees TCS has in India and how many employees TCS has outside India? Infosys, Wipro. Tatas are now the number one employer in UK. Tata Group employs more employees in UK than the UK government. So you can imagine like India's position and power in today's era. प्रधानमंत्री तो थोड़ा राजनीतिक कारणों से भी बोलते होंगे, लेकिन मैं विश्वास करता हूं कि ये अमृत काल है, भारत के लिए अमृत काल है। और ये अमृत काल जो स्टूडेंट्स बैठे हैं, छात्र बैठे हैं, ये लेके आएंगे। और आज का जो हमारा एजेंडा है, मैं बधाई देना चाहूँगा अपने कोलीग्स को FSII से, और जो हमारे चीफ गेस्ट हैं डॉक्टर पड़ौदा, डॉक्टर महापात्रा, उनकी सपोर्ट के लिए भी कि भाई हम इस महत्वपूर्ण विषय पे बात कर सकें। मैं थोड़ा सा मुद्दे की बात करूंगा। FSII जो फेडरेशन ऑफ सीड इंडस्ट्री ऑफ इंडिया है, वी आर फोकस्ड ऑन टू थिंग्स: इनोवेशन in Indian seed sector. All the member companies of FSII, on an average, we invest more than 10% of our revenue on R&D. और R&D पे खर्चा करेंगे तो इनोवेशन के लिए करेंगे। इनोवेशन होगा तो नए बीज आएंगे, नई टेक्नोलॉजी आएगी, नए ट्रेड्स आएंगे, प्रोडक्टिविटी बढ़ेगी। प्रोडक्टिविटी बढ़ेगी तो किसान के पास, किसान की आय बढ़ेगी, किसान की आय बढ़ेगी तो देश की GDP बढ़ेगी। अभी भी 55% of the population is dependent on agriculture. So role of IPR in agriculture seed sector is very important for innovation. मैं कुछ तथ्य रखूंगा आपके सामने। R&D as percentage of GDP of a country, highest है South Korea. South Korea almost 5% of their GDP invest in R&D. Germany, they spend about 3%, US 3.5%, China 2.4%. देखिए, अगर चाइना का GDP आज 14-15 ट्रिलियन डॉलर है, उसका 2% goes into R&D. US is now more than $30 trillion economy, and they spend 3%, 3.5% of that on R&D. We still in India, our R&D spend is 0.64%, less than 1%. And one of the reason for this is like बौद्धिक संपदा का अधिकार, ये उससे जुड़ा हुआ है। देखिए, कोई इनोवेशन करता है, आविष्कार करता है, उस पे उसका अधिकार है, हक है। हमारे IPR जो कानून है, प्रावधान है, अभी भी हम एक विकसित देश होने की बात कर रहे हैं। विकसित देश होने के लिए ये सब चीजों में हमें समानांतर प्रोग्रेस करनी पड़ेगी। हमें उसी तरीके के IPR राइट्स लाने होंगे, नॉट ओनली इन अदर इंडस्ट्रीज। ये नहीं कि IPR इज इम्पोर्टेंट फॉर IT सेक्टर और मेडिसिन सेक्टर ओनली। IPR इज वेरी इंपॉर्टेंट फॉर एग्रीकल्चर। IPR इन एग्रीकल्चर विल प्ले वेरी इंपॉर्टेंट रोल। आज सुबह ही हम बात कर रहे थे प्रोडक्टिविटी। हमारी धान की फसल मुख्य फसल है। हम अभी पैडी प्रोडक्शन देखेंगे, अनमिल्ड राइस तो 4.5 टन पर हेक्टेयर हमारा एवरेज है, औसत है। वियतनाम 5.5 टन पर हेक्टेयर है, चाइना 7.5 टन पर हेक्टेयर है, यूनाइटेड स्टेट्स अराउंड 8.5 टन पर हेक्टेयर है। और हम 44 मिलियन हेक्टेयर में धान की खेती करते हैं। हमें 44 मिलियन हेक्टेयर में धान की खेती करने की जरूरत नहीं है अगर हम प्रोडक्टिविटी को 6 टन पर हेक्टेयर पे लेके जाएं, और वो हो सकता है। नया बीज आएगा, नई टेक्नोलॉजी आएगी। अभी ICAR ने भी डेवलप किया है एक ट्रेड धान में, HT राइस, नॉन म्यूटेंट, इट्स ए नॉन GMO म्यूटेंट ट्रेड। प्राइवेट सेक्टर की तरफ से भी सेम टाइम में डेवलप किया गया, मार्केट में आ रहा है। दिस इज ए बिग न्यूज इनफैक्ट दैट इस बार पहली बार भारत में एक HT राइस इंट्रोड्यूस हो रहा है। और ये हो रहा है बिकॉज लोगों को लगता है, ICAR इसलिए बोला कि बिकॉज इट इज IPR इज वेरी इंपॉर्टेंट फॉर द पब्लिक सेक्टर ऑल्सो सर। और प्राइवेट सेक्टर में हमारा जब भी डिबेट होता है, स्पेशली बहुराष्ट्रीय कंपनियों में, कि भाई ये टेक्नोलॉजी है, हमारे हेडक्वार्टर्स में जो इंटेलेक्चुअल प्रॉपर्टी के एक्सपर्ट्स हैं, लीगल टीम है, वो हमेशा डिबेट ये करेंगे, इंडिया में टेक्नोलॉजी लेके जाएंगे भाई, बचेगी नहीं। तो हम दोनों जगह के बीच में, मैं राजवीर से बात कर रहा था कि हम रिश्ते हैं, क्योंकि वहां पे हमें अपना भारत का पक्ष रखना है। जब हम बात करते हैं अपने हेडक्वार्टर्स में, वहां पे डिबेट होती है नहीं नहीं इंटेलेक्चुअल प्रॉपर्टी कैसे बचेगी। तो अभी हम क्या बोलते हैं कि देखिए साहब मार्केट बहुत बड़ा है, 20-30% लीकेज भी होगा तो भी बहुत बड़ा मार्केट है, जाइए वहां पे। लेकिन वो बहुत अच्छा हमारा आर्ग्यूमेंट नहीं है व्हेन वी आर्ग्यू ऑन दीज लाइंस। So I'm hopeful that today's session will come out with some discussions, proposals, recommendations that in future we strengthen IPR in Indian seed sector too. Thank you.
Thank you so much, sir. May I now invite Dr. Yogesh Pai, Associate Professor Law, in charge of DPIIT IPR Chair and Co-Director, Center for Innovation, IP and Competition, National Law University, Delhi, for a special address, please. Thanks.
Suchi, right?
Yes.
Thank you. So, at the outset, I would like to thank our partners, FSII and PUPFRA. So, as a co-host and a partner to this event, we are extremely honored to be associated with these discussions. We are at a very critical juncture in the march and progress towards intellectual property rights in our country. But before I start, my address for the day, I would like to remember and place our condolences to the demise of passing away of Miss Sunita Sridharan, who was empaneled as a legal officer, legal lawyer of the PVPFRA. She passed away yesterday. So I think in a room full of lawyers and people who are practicing PVP law, they would be very well knowing her. She was a very vocal proponent of intellectual property rights in the country, and she died at a very young age. And we are very sorry to have heard that news last evening. So. So I would like to dedicate today's address and our partnership with the cement and dedicate it to Ms. Sunita Sridharan. So one of the things that I think frequently we do not much think about is the origins of PUPFR law in India. And it seems like the origins are pretty recent, just a couple of decades back. But if you go back to the historical roots of discussions around this law to incentivize the creation of new plant varieties, there was a seeds team report in 1967-68. And that was the first time when a proposal was made, but the proposal went nowhere. The UPOV treaties happened, etc. But India remained out of that space on the question of incentives. And this provides us a real kind of real world experiment as to what happens when you do not have a law that incentivizes innovation in be it in any sector, including the seeds sector, because it was only after in the late decades, due to market competition, etc., when there was thrust towards thinking about it, and of course the World Trade Organization's agreement on TRIPS mandated that you have either patent protection for plants or plant varieties, or you do what is called as a sui generis, effective sui generis system. And that's where we are on the effective sui generis system in the country. What I would like to emphasize today is that there are a couple of things that are very important in the institutional design of property rights from the perspective of the law and how the law is structured. One is the rights, the scope of rights, clarity on the rights, and also clarity on the remedies. Because there is a Latin phrase we call ubi jus ibi remedium, which means where there is a right, there is a remedy. And the previous speaker, Mr. Rana, was emphasizing on the question of enforcement. And I think even the opening remarks emphasize this. So remedies is an essential component along with the rights. But having said that, because we have laws that where rights are clearly identified, but there are questions of overlap. Without referring to any kind of current litigation or past litigation, including some sub judice issues, I would like to bring out one of the questions that has frequently come up in the Indian context as to the interface between two set of rights that we have created for one is for the plant variety and the other one is for the question of plant related inventions. So those may not be particularly directed towards plants as such, but then those are microbiological processes, or they may involve microorganisms as such, and they could of course be protected through the patent law itself. And this unique interface also creates a little bit of lack of clarity on what are the scopes and remits of the patents law, because the patent law is very differently structured institutionally when compared to the plant variety law. Because in India, the plant variety law also has farmers' rights. In the institutional design of patent law, the exceptions are never called as rights. But in the context of Plant Variety Act and Farmers' Rights Act, we have specific farmers' rights that are assigned. So that, I think, divide is pretty much clear. But this interface and the lack of clarity on inventions vis-a-vis variety has created some amount of litigation, which I would not want to directly discuss. But I think one of the essential things that is needed is for both proponents of patents and plant varieties to actually, sit together and find out what are the, remits of each of these laws. Because essential clarity on what the property rights are is very important, not only for the people who are investing in research, but also important for competitors and downstream, what you call um, entities in the seed sector who are going to implement these technologies. This is point number one. Point number two is that in the institutional design of intellectual property rights have a particular meaning. And the meaning that is attributed to property rights is based on the idea that these are exclusive, in the sense that these may not be exclusive monopolies, because monopolies is based on creation of market power, in the sense that depending on how much market values your product, market power is created. But IP rights in themselves do not create that market power. They allow you market exclusivity based on the utilization of which you generate, because of the what you call goodness of the product, you generate market power. So I think one thing that needs to be also clear is when we talk about institutional design of intellectual property rights, we often conflate at various places between property rights and liability rules. Liability rules is a situation where someone intervenes in the what you call the market mechanism, and then says that, okay, here is a place where we can decide on, say, for example, what royalties are to be paid to the what you call incumbent innovator, etc., or a breeder, etc. In such a situation, there is often a kind of a lack of clarity as to what are the expected returns in a particular market or in a particular jurisdiction. And that if it is not clarified and clear ex ante, then it could lead to some kind of what you call not a leakage in terms of property rights, but a lack of clarity for those who want to sort of do research, and also those who want to utilize that research in the seed sector. So that is another point I wanted to convey. The third point and the last point I want to emphasize is on there must be clarity in the instrumentalities. The clarity in the instrumentalities particularly means that if you have IP laws are essentially the normative objective of the IP law is to protect. And if there are overwhelming public interest requirements which are there in the law, there must be absolute clarity on the metes and bounds of those public interest provisions, primarily because that is also one of the aspects that Indian law and laws in other jurisdictions also emphasize upon. But that relationship between property rights and what you call public interest provisions in the law must be very clearly established. The second is, this is not the only kind of a layer that limits property rights, but there are other kinds of options in the law that are frequently used, including in India, where you have what is called as provisions in the contract law, and what kind of contractual provisions are good or bad. So contract law enforcement also then becomes kind of tricky. You have competition law also being applied as meets and bounds of the IP system, primarily because there could be situations where there could be abuse, etc. And then you have external regulation based on market failure. To me, these the instrumentalities or the legal instrumentalities are still to reach a level of finesse and sophistication in India where we are able to clearly distinguish and read provisions of the law that are based on its normative objectives. So the IP system, if its job is to protect, then the overwhelming public interest exceptions must be very clear. Property rights also must be very clear. Second, if there are contractual conditions you say are not valid as per the provisions of the contract law, there must be at least some clarity during contract formation. Otherwise, these kind of issues often get litigious, and that's one of the problems that we can face. Third, when you look into competition law, you must be very clear that there must be an abuse of market power, and how you construe that of abuse in a innovative and what you call as dynamic competition is very distinct from other kinds of market where there is purely issues that do not involve any kind of innovation or creativity. These are commodities, pure commodities. And fourth is regulation, particularly exercise of price control measures, etc. We must be absolutely clear as to how we arrive at the question of what is market failure, because that is the economic underpinning of the law, that there is market failure. Otherwise, if you want to exercise simply public interest in exceptions and there are overwhelming public interest concern, you can very well do that within the existing rules of either the patent system or the PVPFRA system, because both have compulsory licensing provisions. So clarity in the instrumentalities is what the call for today, because we are not very clear in spite of a lot of litigation. It seems like there is no final conclusion, at least from a legal perspective. Because I come from a law school, I thought I would appraise the audience of this kind of a dilemma that we usually face, because students ask questions. Why is all of this look similar? And then we don't have answers. So let's see whether we can find some answers today. Thank you. Looking forward to the event. Thank you very much.
Thank you so much, sir. May I now invite Dr. Trilochan Mahapatra, Chairperson, Protection of Plant Varieties and Farmers' Rights Authority, for a special address to the audience, please.
Thank you very much. Good morning, everybody. The chair of the session, Honorable Padma Bhushan Dr. R.S. Barodaji, Mr. Ajay Rana, Chairman FSII and Managing Director and CEO of Savannah Seeds, Dr. Yogesh Pai, National Law University, Delhi, Mr. Rajbir Rathi, Vice Chair FSII and Head Agricultural Policy and Stakeholder Affairs, Bayer Crop Science, Mr. Raghavan Sampath Kumar, Executive Director FSII, many luminaries, experts, and also, as it was said, that there are some students from National School of Law, and my colleagues from PPVFRA, and I see many knowledgeable, honored people from various organizations present here, including Dr. Jess Gupta, Dr. Bansal, and Dr. Vassal, and many others. I don't want to take names one by one, it will take time. But thanks to FSII for organizing this program and inviting me to be part of this program, and also giving opportunity for PPVFRA to partner in organizing this program, this conference. In fact, my time is already over, So, so I was supposed to finish at 10:40. It's already 45, and but I'll take 10-15 minutes. I beg pardon for this delay. Delay start on my part. So many things have been spoken, and we are talking about uh, three keywords: innovate, protect, and prosper. Very relevant in today's context. You all know that India is doing pretty well in the arena of innovations. Global Innovation Index, if you see, in 2015 we were at the 81st position, 81 out of about 131, 32 countries. And today, in 2023, the WIPO Global Innovation Index reveals that we have climbed many stairs up, and we are now at 40th position. So from 81 to 40, in a span of say about 9 years, 8-9 years, say very good progress, and so India is innovating. So that's the satisfying point for all of us, that India is innovating. And also this position, 40th position, tells us that we have to do much better. It's a long path we have to traverse, and obviously not easy path to traverse. And how do we innovate? Mention was made about the ancient innovators in this country, the rishi, the kind of saints, the way they were living, the way they were thinking, the way they were innovating. So there are a lot many things for the whole world to take note of, and in fact also copy those ideas. And how many of those is happening today, that's a different issue to discuss. I don't have time to really deliberate elaborately on each one of those. But certainly, it's a country of innovators. It has been a country of innovators. But how the global community has moved, mention was made about South Korea. In terms of investment, a small country, and how much investment happens for innovation to be there, and how much we are investing. So that's one kind of area where we need to really bother and have the right kind of policy framework in place. Everyone present here and otherwise, we must deliberate on this. This is a very, very important issue. On various fora, this has been mentioned that India should invest more. But I think there is a need to have a big push to this to happen, that at least 2%, China mention was made, that should we not really invest to that extent? We always compare with China in every respect, and why not in this respect, that can we invest more? And public investment, private investment, National Research Foundation has been put in place, and there is scope for public-private partnership, and there are many examples in the past where there was scope for public-private partnership for greater investment in research. And how do we really promote that? And all of us sitting here from the seed sector should actually ponder about it. How do we, in addition to investing 10% in our own research, how much we can do together on specific areas and aspects of common interest, where the strengths of public sector can be taken advantage of to solve a problem that a private sector sees and would like to solve with the help of expertise available in the public sector, and how we can join hands, public private together, to address some of those challenging issues and the problems which are staring at us for a pretty long time, and we have not been able to really resolve those, or the emerging challenges because of climate change and the necessities of more food because of growing population and so on and so forth. So I'll not go into that part because time is again limiting. So that is one aspect that we must innovate, and that culture must start from schools. When child starts asking questions, the parents don't have time and patience to actually answer those and guide children at those formative stages to answer their queries appropriately and create that inquisitiveness in them and nurture them starting at home, and forget about schools, the kind of teachers and the kind of vacancies, the kind of recruitment happening and the way recruitment is happening. All these are issues. I think this is another area. Unless we address that, I don't think we will be a country of innovators. So there is not only investment, which is important, but we have to nurture that kind of mindset from the very beginning, from the home and the four corners of the home, confines of the homes. It should start from there, and the parents have to have sufficient time for nurturing innovations in that kind of mindset in children, and subsequently in schools. So that that culture grows, and we have a country of innovators. So that is another important point which we are missing out very badly. Go to states and you see the situation happening, that is prevailing in schools, the government schools, even some of the private schools, many of the private schools rather. The mushrooming of private schools, the quality teachers are not there, the laboratories are not there, the facilities are not there, the infrastructure is missing grossly. So there are many issues, and this has been analyzed and studied in detail. I'll not go into that part. So I'll stop that part here. So we must innovate. And without innovations, what to protect? What to protect? What is there to protect? And we say that we have patented, 80,000 patents last year. And what are these patents? 50% came from outside. Those companies from South Korea, from Japan, from China, they are patenting in India. 50% are coming from those, not Indian patents developed by Indians or the Indian entities. So what we are patenting? So unless we have that kind of innovation, there will be nothing to patent. So we have to innovate fast, and we need investment. We need a kind of environment for that to be nurtured, to grow, and in the process create IP, intellectual property. Unless there is innovation, and where from intellectual property come from? There would be all provisions of law and then everything. So if there is no intellectual property to patent, what to patent actually? And that is the situation. Though we have 80,000 patents, only 50% is coming from India, from so-called IITs and ICARs, and you all taken together everything, and AIMS and so on and so forth. So that's the situation in the country, and we need to really ponder over this very seriously. The other is that we should protect, and we should protect. Gone are those days, this country, have cultivated the philosophy that Sarvajan Hitai, everything open for everybody. Whatever I create, It's free. Take it. And that was the situation, before WTO and, all the agreements and those kind of, I'll not go into those again, details of it. Sarvadan Jan Hitai, everything. And that's what we have kept everything open and free. But certainly, in the changing environment, we signed, we became part of WTO, and then we signed TRIPS agreement, and we have certain commitments, and then, particularly with regard to plants, and we created PPBFRA. And we created a PPBFRA, sui generis system, to protect the IP with regard to plant varieties. A lot of issues related to law, which was mentioned by Dr. Yogesh Pai, and I will not be able to really dwell in detail. How do we protect and how we are doing. Very briefly, I'll tell you that so far we have received more than 18,000 applications for protection in this country after creation of this wonderful system that we call the indigenous system to protect. 18,316 applications we have received. Public, private, farmers, that's what mention was made, that farmers' rights. And, let me tell you why farmers' rights. Where from the plant diversity came. Plant diversity is the base of development of all new varieties. We have today biotechnology, we have gene modification technologies, but what is the base of that biotechnology to happen? The base is coming from this diversity which has been maintained by the farmers for ages. So that's the reason why they are important. They continue doing that. And that's the reason why India, globally also, it was thought that farmers, certainly their interests, because they are the custodians of the plant biodiversity. They have been maintaining those. If you do not maintain those in situ, on the ground, in the field, then the evolution is not going to happen. It's not going to evolve in your gene banks. They are evolving. They are maintaining. They are spending their time. They are the biggest innovators. They are the greatest innovators on earth. Let's not forget that. So, how do we pay for their innovations unless we protect their interest? And that's the reason why it is equally important to think about them. And my students, friends from law schools must take note of this particular observation, that how important it is. And how do we strike a balance? I say this before every audience, and those particularly coming from outside, they ask this question, that how India is striking a balance. I say that informal seed sector is about 25-30% now. A recent assessment will say exactly where we are. Maybe it is 20-25%. Even if we say it is 30%, what about the rest 70%? Out of rest 70%, which is formal seed system, how much is the government? Maybe 30% of that, maximum 40%. And 60% of the rest 70% is the private. So everybody has a scope to exist and grow and perform. And that is how Indian seed sector is growing. And as per one estimate, it is supposed to grow in another 10 years from 24 to 32 at the rate of CAGR of 10%, which is quite high. Another estimate says there's a CAGR of maybe 5.5 to 6%. So the seed sector is also growing, and the outlook is quite bright for Indian seed sector. The other day we were discussing in the ministry that the global trade with regard to seed from India is not really huge, less than 2%. And can we really have plans and programs and join hands so that it is increased to 10%? 10% of global seed market, and all of us together, the multinational, the national seed companies, and the public institutions, and everybody, the expertise available together, can we contribute to 10% of that global trade? So how we promote this? Is there a scope to protect? Yes, as I said, that we have these many applications, and so far we have protected 7,115 plant varieties. 7,115 plant varieties. And certainly, there is scope to improve on the processes which are there, the provisions which are there. Mention was made that how do we enforce the law adequately so that the protection which is granted is respected. And who is violating? Hardly the farmers are violating this. Hardly one example you will find where farmers might have violated. And if we say that is a violation, and who is violating? One private company violating the rights of another private company? Who is fighting with whom? So that needs to be really very seriously discussed. And can those which are being fought in the courts can be settled across the tables, sitting across the tables and discussing how do we share profits, the benefits, forget about farmers' rights. How do we share benefits among us and then solve our problems? So the protection is one thing and violation is another thing, infringement is another thing, and how our law can, how law operates in our country. It will take 20 years and 30 years to resolve a case, maybe 50 years to resolve a case. And if you continue doing this, we will never be able to resolve infringement cases and violations, and mention was made about enforcement. It's not easy, and talking is easy, discussing is easy, and resolving those is not easy, given the nature of our legal system, how protracted those legal systems are, and how we argue and counter argue, and how we place those cases, and distorting facts in many ways. And there are evidences with us, and how do we really do? But in the law also, there are deficiencies. We need to really evolve. We formulated that 15 years and 20 years ago. We need to really relook at those points and provisions and need to really change. This is high time that we need to really very critically, in an unbiased way, need to really look at those weaknesses and those weak points, and then modify those so that we adequately address those weaknesses which are existing. And I must tell that when we talk of protection, that we are protecting, but there are two points which I must mention. One is the provisional protection. We did not really elaborate on this, despite the 18-20 years of our existence. And and this is a very important concern of the private. And there are violations during that phase after submission of the application and grant of the certificates. So it might take 5 years and sometimes even 6 years because of various reasons. I'll not go into those details. And we thought probably this is high time that we have to describe in detail that the procedures and methods and rules and guidelines so that we are able to provide adequate safeguard against infringement during that period of provisional protection of say 3 years or 4 years or 5 years. So that is very, very essential. And Dr. Rajesh Gupta is here, and the committee has been formulated and we are deliberating, and we certainly would be able to provide that in another 3 months time so that we have adequate protection. And this particular weakness which is existing in our it is not there in act, but somehow we have not really elaborated that in the form of rules, and we should be able to do that in another 3-4 months time. And the second important point is we never bothered about the special traits. And you say that you have now whole number of special traits which are getting modified and for which varieties are known. And my time is over. I'm looking at in 15 minutes is over. So I should finish now. So, and the special traits we never bothered in 20 years. Now, so we have, formulated committee and, building on to what was existing so that we have special traits, are recognized, identified, and protections are granted for those special traits. So that any variety which is described for DUS characters, normally whatever is there in UPOB and other kind of country provisions, and they are there, but they do not adequately describe the varieties. Without special traits, varieties have little meaning. If they don't mention drought tolerance or salt tolerance or disease resistance or high protein or high zinc or high iron, if don't variety are not described and protected for these traits, the varieties have no meaning actually. In today's context, in the context of climate change, in the context of prevailing malnutrition, so that is another area of protection which we are looking at. So certainly protection, and there could be many other things to talk about, but time is not there. I'll stop here. But to prosper, how do we prosper? Prosper together. Prosper together. The country must prosper. How do we prosper? As I said, the seed sector is growing. But if we don't really build, you say 10 trillion US dollar economy or 30 trillion US dollar economy, you have targets. We must be third largest economy. So how do you do that? So from 2% to 10% of global trade, can we really do this together? So what is prosperity? Not individual prosperity. Individual prosperity is very, very important. The company must prosper. Without profit, why you will really work for that? And we have to work together. And we have to. That's the reason why, now we have opened up. We are discussing with industry almost daily basis so that your perspectives are understood. Unless we work together, we will not be able to really address those bottlenecks which have been ailing the industry. And one of the objectives of the PPVFR Act in 2021, it was formulated, and Dr. Paroda is here, certainly he will speak about it, that when it was being formulated, it's very clearly enshrined in the objective that this is to stimulate investment. We have to encourage the private sector investment for innovation to happen. Innovation has to happen through protection. If you don't grant protection, obviously innovation is not protected. And if innovation is not protected, investment will not come. And investment doesn't come, so innovation doesn't get that kind of support. So these are all the objectives of this particular act. And we need to really do that instead of blocking everything, closing our eyes, and not really working together. So obviously it will not solve the problem. So we have a long way to go, and we have initiated the right earnest, and hopefully we will be prospering together. And the country must prosper, the industry must prosper, and the farmers must also prosper. And we must not be losing sight of those farmers who have been innovating in their own way to protect, to first of all, to identify those local types and diversity, and as custodians, to be maintaining for ages. And today you will see very many poor farmers. They are so involved and dedicated. In their small patch, they are maintaining hundreds of germplasm lines. What they get out of it, it's not commercial cultivation, but still they continue maintaining. So we have to also bother for them. And that's what our objective is. And we can live together happily and prosper together. With these words, thank you very much. And let's work in that direction. And certainly we will succeed. And also set examples for the global community to follow and emulate. Thank you very much. Wish you all the very best.
Thank you so much, sir. May I please invite our session chair, Padma Bhushan Dr. R.S. Baroda, Founder Chairman, Trust of Advancement of Agricultural Sciences, for a special address, please.
Today's chief guest, Dr. Mahapatra, the new president of FSII, Dr. Ajay Rana, Sri Rajvi Rathi, Dr. Yogesh Pai, Mr. Raghavan, many distinguished colleagues here, which I see in the audience, starting from Dr. Vasal, Dr. H.S. Gupta, Dr. Bhagmal, Dr. Karihalu, Dr. Bansal, Dr. Dadlani, Kaushalji, and other distinguished delegates, ladies and gentlemen. It's a pleasure for me to be here, and I would like to thank FSII for their invite. I would also like to congratulate Ajayji for and to you, Rajveer, for taking over this new responsibility for FSII. I think we must congratulate them and also wish that this is not the first, but many such activities will be uh, undertaken by your organization. Uh, the visibility of FSII is now quite evident, and we do appreciate that such organizations are responsible for promoting the seed sector in the country. I would like to also compliment you for the topic that you have selected for this discussion, that is innovate, protect, and prosper. And also in the context of IP protection, how can this take India's seed sector to a newer height? Much has been said by Dr. Mahapatra and others, and as he said, time is over. Perhaps my time is much more over. And I don't want to further uh, delay your tea break, but Rajveer tells me that possibly I have to justify my tea, so I must speak. And in that context, let me start with the first aspect of innovation. Those nations have progressed faster in agriculture sector where they have uh, taken up major effort to innovate and scale those innovations for the benefit of the society. Green Revolution was a innovation led around those dwarf wheats and rices. We would have possibly not otherwise achieved our food and nutrition security. Uh, when we had met at global level in 2010 in Montpellier, involving GFAR, with which I was associated, and CGIR, it came out very clearly that now you need a paradigm shift from agriculture research and development to that of agriculture research and innovation for development. So now time is for innovation, not for research publication alone. And to have products of your innovative mind, as was mentioned earlier, and IPs are needed to provide you legal right for that kind of innovative innovations that you have come out with. And in that respect, therefore, we would require some legal protection of whatever new ideas of my mind have led to an end product which is useful for the society. People say that innovations should not be only innovations, but they should be disruptive innovations. And for that, when we say disruptive innovation is like this smartphone, which has reached the society at the highest level and at the lowest level, and which helps us today in moving much faster. And in that context, again, when we look at we would require the promotion of uh, more of research and effort in a not only public sector but also in the private sector, and now the time is ripe for public private partnership as well. So we have to see how we can work together and come out with new uh, innovations, which we call in Hindi नवाचार, और बौद्धिक संपदा जो आपने कही थी उसको प्रोटेक्ट करने की आवश्यकता है. But for that, you then require to apply for patents. And when I look at the comparison that is there with regard to applications filed in the last 1 year globally, China is much ahead now. It is almost 10.5 million applications for patent were filed in 2022 as compared to 5 million in US, 4 million in Japan, very small countries, but see the kind of emphasis on innovation. Therefore, what is required is, and when you compare with Korea was talked about 2.7, Germany 1.5, and India is though making progress, and we are trying to catch up, but it's still only 1 million. So there is definite need for accelerating the space for, and not only you apply for patents, how many of them have been granted is also an issue. And many scientists don't even know how to apply for patents. So that knowledge also would be required, a kind of legal understanding of the people like what Roy had mentioned is necessary. The other point is with regard to the protection, therefore, and protection, luckily we have IPR Act. We also now are fortunate to have our Plant Variety and Farmers' Right Act. I would like to differ from Roy in the sense that our Plant Variety and Farmers' Right Act is having a kind of uh, lack of harmony with that of IP Protection Act. We are providing equal, provision for protection to the researcher as well as to the farmer, presuming farmer is also a researcher, and therefore the protection is to be considered equally on that basis, and one should not just worry that name of farmer has been added. And we wanted to actually join UPO long back when I was in the council and realized that they had modified their condition of the relaxation that earlier was available for the uh, farmers to protect their seed, and then they had brought in the 1998 provision where that aspect was removed. And then we said we would like to join in 1971 provision. And then they said it is not possible. So we said, okay, what can we do? And in that context, we then decided to go ahead with our own Plant Variety and Farmers' Right Act. And this is a unique act. This is the only act which got passed in a record time in the uh, in the history of anywhere in the world in 4 years' time. When we started and we uh, got it cleared from the parliament. And then obviously when we look at protection, there could be patents, there could be copyrights, there could be trademarks and trade secrets, geographical implication, plant varieties, and also industrial designs. But our emphasis has to be in today's context more for plant varieties in particular. And we are fortunate that we have now a protection uh, domain existing, and we have come a long way. What Dr. Mahapatra said, so many varieties have been registered and much more can be done. And he is taking steps to further improve on the facilitation process, particularly because it is not only that you think that you have a uh, law, so you must only govern the so the Plant Variety and Farmers' Right Protection Authority also is there to facilitate the process. Otherwise, farmers' varieties would have never been registered if it was not there. And farmers don't know how to apply also. So it is an education to be provided to them. And that's, you have to appreciate that I think 50% of the varieties that they have registered are of farmers. Even the government registered varieties are at number 3, and the private sector varieties are at number 2. So we have to, otherwise, if this was not there, whatever farmers' innovations are there would have never been recognized, and they would never gain any benefit. No doubt, we have to see that they receive the benefits for their innovation. But for that, still much is required to be done. Now, coming to the third point which I have is about, according to your own agenda, prosper. Prosper, our Indian seed industry made a beginning, I think, in early 60s when we have here uh, Sanjay Deshpande sitting. Dr. B.R. Barwale started with the uh, production and sale of the ladyfinger bindi pusa sauni, taking the seed from Dr. Harbhajan Singh and then taking it to the field. And that's from there we have come a long way. Today, what Dr. Rana said, our sector is very robust. It has come a long way. 550 seed companies in the country. I think outlay of about 3 to 3.5 billion annually. No doubt we have to catch up on export where we are lagging behind only 1%. So we have to think how we make it 10% at least in another decade, or we talk about Amritkal. So there should be some target for it. But the seed sector has grown, and you have to appreciate that side by side in the public sector, because earlier there were no private seed organizations or companies. So mostly it was the public sector's responsibility. And we started with the Seed Act of 1966. National Seed Corporation was also established in 1960. So we started prospering through some kind of institutional mechanism that was put in place. And then we came out later with our seed control order, where licensing for selling, exporting, and importing was permitted. And then in 1988, when I was in the council for responsible for crop sciences, we started the initiative for new seed policy. And I think that new seed policy made all the difference. All the difference in the sense that we allowed at that time commercial seed production and also sale by the private sector as an authorized system, import of vegetables and flower seeds under OGL, Open General License, and we also permitted time-bound quarantine system so that bulk seed when is imported, we have our own robust quarantine system, and FDI was also permitted in seed sector at that time. And these were all in that particular new seed policy, which made all the difference. And the foreign development, foreign direct investment then led to entry of multinationals in the country. And today, multinationals are also there, but our national seed companies are in no way less. Rather, the best seed producing with highest outlay are those which are in the national seed companies. More than 10,000 crores, 1,000 crore, 5,000 crore, and when you look at it, and they have not been taken over by multinational. So sometimes there is a fear if multinationals come, the national companies will be taken over. I think we have to strengthen our own system to a greater extent. Then we have been wanting the revision of the Seed Act for last more than 3 decades. We came out with a draft. I was myself responsible that time, and in 2004 new seed bill was also placed in the parliament. But 20 years have gone, not yet cleared, which means we have to now make sure that we have a forum by which we raise the voice that this is important for further growth of seed sector and this bill must be passed at the earliest possible. If there is a need for any discussion on the draft that is there, then that should be initiated. And we must ensure that sooner we have a, a better enabling environment, because what you require for prosperity or for further progress of any sector is enabling environment, and enabling environment must be provided, and that's the kind of enabling environment we provided earlier when we uh, had this plant variety protection authority created. Lastly, I would like to say that many of the private sector seed companies are still uh, either producing and marketing or just buying and marketing. Only 15% of the companies are R&D. How can we ensure that these companies uh, increase in number, and possibly what are the constraints that have to be made available? And I would like to also mention that at that time when there were no research facilities with the private sector, we in the ICR decided to provide the seeds of our hybrids, parental seeds of hybrids, free of cost to the private sector, so that seed is produced and made available to the farmer. This was a unique decision taken, and rather bold decision taken, which led to faster growth of the seed sector. Now, of course, there are many hybrids with the private sector, and we know the growth that has taken place through single cross maize hybrid. In just last 2 decades, we or 25 years, we have increased our maize production from 10 million tons, where we were stuck up by 2000, now 37 to 38 million tons. Also, when you look at the BT cotton, the government provided the facilitation role for regulatory system, and BT cotton was released in 2001, and we became in just 1.5 decades time the global leader in cotton production. We almost reached, and we had beaten China by having about 40 million bales of cotton produced. Now it is coming down, and we have again come at a second place. So we have to again see, and that is because I think our regulatory system is stuck up, and if the HTBT event is cleared, which is already there in the final stage, progress will be much faster. So sometimes these regulatory requirements also are important, and they need to be addressed and to be given proper attention. So finally, what is that way forward for us? And in that, I would see that I mentioned our seed bill need to be passed by the parliament on priority. We must have a relook and revisit our national seed mission, and try to incorporate those elements which will facilitate the growth of private sector, not only the public sector. That I think has to be, even I have been, and our task has been arguing that if the if the incentive is given to the public sector for production of hybrid seed, why not incentive is also given to the private sector if those hybrids are good and making an impact in terms of higher productivity? We have to strengthen our research and development both in public and private sector. We must try to build public-private partnership and provide enabling environment at the institutions because that's what the support national system now can provide. And we also have to bring in the ICR a kind of corporate culture. In Brazil, in Malaysia, Mardi, Embrapa in Brazil, they are all on the corporate design, and they work in hand. Also in the US, they work hand in hand with the private sector, and any end product when is there, then there is access and benefit sharing. But I think we have never met across the table and tried to understand how this kind of partnership can be further built and what are the success models of it. And there is already a mechanism of private to private licensing and sub-licensing. Why can't there be in with the public and private sector for this licensing and sub-licensing? Where is the hesitation? Only thing is we have to place our cards open and build the kind of trust which is required for building this kind of partnership. Then finally, about PVPFRA, Dr. Mahapatra has already made lot of, you know, uh, important statements in terms of how it is moving forward to provide more support. But yes, I also endorse him that there is time now to revisit and see where more facilitation is possible for accelerating this process of varieties and hybrids. Because when you look at the coverage now, maize is giving you the highest return in terms of or highest growth rate for production and productivity compared to any other cereal crop, which is more than 4 to 5%. But then area covered so far, and we have come to 35 to 40 almost million tons, but then area so far covered is only 60%. In case of bajra, we have been talking. I come from Rajasthan. No farmer wants any other seed, but he will say, मुझे तो संकर जाति का बाजरा चाहिए. उसको और कुछ नहीं चाहिए, उसको पैसे की कोई परवाह नहीं है उसकी. And we unnecessarily talk about why prices are high, farmer should be not taxed, but farmer wants that there is a benefit, and then coverage under bajra hybrid today is only 40%. So, and case of hybrid rice we were talking. We started this project, a hybrid rice project, a hybrid research project in 9 crops, in which hybrid rice also came up in 2000. And Yuan Ping had come here at my request 3 times to train our breeders. And we came out with the first rice hybrid at that time. And then in last 2.5 decades, how much area? Out of 44 million, we have only 3.5 million. Today, we wanted at least similarly 15%, 50% what China had. China had 30 million acre area, hectare area, and coverage is 50%. So sky is the limit, but we need to really, and we have seen that increase in productivity is possible mainly through promotion of hybrids. No doubt varieties also are required, but our emphasis should go. And for hybrids, we cannot move forward unless private sector is robust, is strong, and move forward. So with this, I would like to say it had been a great pleasure. I would like to thank once again the organizers, and I see you have very interesting, you know, program for discussion today as lined up, and a lot of legal issues will be discussed, and that should help us to move forward. And understanding of legal issues is another requirement. Even our NVPGR should have, I have been telling, now a legal department. Time has come where we need to move faster and have better approach for access and benefit sharing. So with this, I thank you all very much.
Thank you so much, sir. May I please invite Mr. Agwan Sampath Kumar, Executive Director at the Federation of Seed Industry of India, for the concluding remarks for this session, please.
Respected dignitaries on the dais and off the dais, I know we are running behind schedule and we won't take much time before we break for tea. But before we go, I just wanted to share my sincere thanks to our FSI leadership, our board and chairman, vice chairman, and everyone, and our special guest, Dr. Padma Bhushan R.S. Barodaji, and our chief guest today, Dr. Mahapatra ji, and Dr. Yogesh Pai for making this possible. Coming together is the first step for us. And of course, we did. And glad to see that there are 120 plus participants in this room. And we are sowing the seeds of a perennial conversation, an ongoing conversation. Now, I just would like to, before we break for tea, share an experience I had last week. The Asia Pacific Seed Alliance, APSA, organized a consultation, region-wide consultation in Bangkok last week, and I was there. There were about 15, 20, or maximum 15 presentations from every region, every country in this region, and everybody was showing that how the PPV mechanism is operating in their country, and everybody was showing that how the system has grown, what are the number of applications received from different stakeholders. One country stood out, that was South Korea, and now I realize that why it did. That was the only country among the 15 which talked about enforcement. Among the 15 presentations, there was the only country that talked about enforcement. And when all the other countries were around 2,000, 5,000, 6,000 applications, South Korea was 14,000. And why? Because they had strong enforcement. So today, we are again starting a conversation on how do we make laws enforced on the ground effectively. And it's not possible by one single organization or an entity, whether it is private or public or government. We need to come together and discuss. And I think we made a strong case for it today. And let's continue this dialogue. And FSII is keen with the support from the stalwarts, the industry veterans, and also our leadership. We are looking forward to organize these kinds of events for the betterment of the industry, not just seed sector, but also for the broader agriculture agenda. And we are happy to we are happy to travel past our comfort zone of having our legal friends also here. I see a lot of lawyers, I see some familiar names. So we are again going to the next level of our own comfort zone to talk to various stakeholders to bring larger level of awareness on these issues. So uh, without taking much time, I thank everyone for attending, and please stay on for this the next session as well as for the panel discussion post lunch. So thank you very much.
Thank you, sir. And everyone, we will now take a short break. Please join us afterwards for our first session on the overview of global, regional, and national policy landscape for IPR in seeds. Before that, let's join for the. We'll do a session picture. So we meet exactly at 11:45 here in the hall. My phone. 11:45 तक कोई नहीं आएगा 12 बजे आगे टाइम से
Okay, Raghavan. Am I audible? Hello?
Doctor, your voice is a bit feeble. Can you please speak a bit louder?
Hello? Am I audible?
Yes, but feeble, doctor. Voice थोड़ा volume थोड़ा increase करो ना.
Volume, it is actually at max only. Let me
No, no, mic. Maybe you can come closer to the mic, doctor.
No, I am putting a cordless.
Okay.
So I am actually putting a cordless.
That's going to be an issue
Oh, is it?
because cordless are usually little low on the volumes. Huh? No.
Is this okay?
It's now better, doctor. But उनको जरा बुलाओ ना.
I have actually, yeah, I have put yeah. Or should I remove everything and only speak without a cordless? Or
No, the wired is fine actually. Wired mic works well.
अभी ठीक है?
Much better, doctor.
Yeah, okay.
Much
So
better.
I have also shared my presentation. It is there on the screen if you can see.
Yes, it is there, doctor. If you can go
Yeah.
to the presentation mode, please.
Okay. So
Yes,
yeah.
we are starting in maybe 3 minutes.
Yeah, okay.
Sure. Video, yes, his video is on. उनको थोड़ा ये करो ना, पिन करो. जो जो स्पीकर है उनको पिन करो. Can you see the stage and the audience, doctor?
Yeah, I can see the stage.
Okay, right. Okay. Now you are online. Yeah, sure. We'll just start in 3 minutes, doctor.
Yeah, let me just know if there are people on the stage so that I can just address them and then move forward.
I'll ping you. I'll buzz you. Sure.
Yeah.
Hello, requesting everybody to please settle down. We'll begin with our session shortly.
You can just
Welcome back, everybody. I hope you enjoyed the break. It's my pleasure to welcome you to this session on overview of global, regional, and national policy landscape for IPR in seats. This session promises to provide insightful perspectives on an important topic. We are honored to have with us today distinguished experts who will share their knowledge and insights. Ladies and gentlemen, we are honored to have with us Dr. Dinesh Agarwal, Registrar General Protection of Plant Varieties and Farmers' Rights Authority, PPVFRA, Government of India. I request you to kindly grace your presence on the dais, sir. Thank you so much, sir. Let us begin this session with a comprehensive overview of the Indian seed sector by Dr. Venkatram Vasantavada, Finance Director of Federation of Seed Industry of India and Managing Director and CEO, Seedworks International. He's joining us online from Hyderabad. Over to you, sir.
Thank you, Surabhi. Surabhi, I'm audible?
Yes, sir, you are.
Yeah. Thank you, Surabhi, and good afternoon to my co-speakers. Greetings to Dr. Dinesh Agarwal, uh, Raghavan, who is Executive Director FSII, distinguished scientist, and ladies and gentlemen. Much has been said in the earlier session, and I just wanted to reiterate some of those points which have been made, more from a perspective of Indian seed sector. The first one is all of us, we know that the size of the Indian seed sector estimated at $6.3 billion is going to almost double to $12.7 billion and obviously be at $20 billion. But at the core of this Indian seed industry, as we all know, is the plant variety development through a conventional plant breeding in the process of genetic improvement of crops. Now, the growth contributing factors need investments in crop improvement and seeds. And I think the speakers earlier in the session have also alluded to that. Crop agronomy, technology interventions to minimize the biotic stress and abiotic stress, improved crop nutrition and fertigation, supply chain management, and of course, the whole new aspect of digitization and precision farming. which we all are witnessing. So I think against this is the story of BT cotton in India. Dr. R.S. Paroda talked about it. I think this is one of the outstanding successes of a technology which revolutionized the cotton farming in India. The yield losses were 30 to 35%, 6 to 8 insecticide sprays. But post BT cotton approval, 7.2 million small cotton farmers in India adopted BT cotton. India became a net exporter and a major cotton producing nation. Production went up and farmers' profits obviously also went threefold. And then this technology added $7.2 billion to the national income and also optimizing the pesticide usage by 40 to 60% less. Now, the reason why we are talking about this BT cotton, Dr. R.S. Paroda spoke about it. R.S. Paroda spoke about hybrid rice and, the hybridization aspects. This is one good case about an innovation which came where the Indian seed companies collaborated with the innovator, and we saw huge benefits to the farmers which have got accrued. So I think against this perspective about what we want to be in 2027 and 2040 and beyond, and what are those requirements needed, let us keep this example as one of the revolutionary technologies and look at IPR, PVP and all with this slide. I think all of us, we know we are talking about Amritkal, the role of the Indian seed industry. Viksit Bharat has been spoken by the Honorable Prime Minister many a times. Make in India or Atmanirbhar Bharat is again something we have all been talking about. And obviously, there are steps which are being taken in those directions. And agriculture continues to be the backbone of the Indian economy and a principal source of employment. And then obviously the good quality seeds is one of the most important input which will help us to ensure that agriculture continues to grow and play an important role in the Vision 2047 of Amritkal. Seed contribution to the total production currently is 20%, can definitely be raised to 45% with an efficient management. So the role of the Indian seed industry is extremely important if India's ambition of a 2047 needs to be met. So we are just trying to emphasize the fact again that how the seed sector would play an important role. And given this, what are the enablers which will actually help us to ensure that we continue contributing to the Indian economy as well as to the Indian agriculture. So I think this Dr. Trilochan Mahapatra spoke about it. I think we should all, kind of congratulate ourselves. A great progress has been made on collaboration between private sector and public sector institutions, independent farmers and others on the plant variety protection. I think this, again, I'm reiterating the numbers, some of which Dr. Mahapatra spoke about it. 7,087 certificates have been issued. Total applications received were 18,303. And then published in the PVP journal is 690, and there are 3,702 applications made. So I think this is a very good example of how the public sector institutions, the private sector, the independent farmers, or any of the innovators can collaborate to ensure that the PVP protection laws, which have been, obviously remodified and in line with the industry's aspirations, can become a success. So I think this is a great story to talk about. However, having said that, there are challenges which are there are issues which are there, and then I think we have to work on it. So more effective implementation is what the industry would like to have. Implementation of the PVP FRA 2001 can be strengthened further. The process of registering the plant variety under PPV FRA can be simplified further. So these are the two recommendations which, on behalf of the FSII, we have been talking about it, but I think in this forum, to set the perspective for further discussions, I think we would like to, obviously debate and also look at the best practices otherwise. There is an ambiguity between patents and plant variety protection laws. I think this was alluded by the NLU Delhi professor also to some extent. Efforts are required to do away with the existing ambiguity between the patents and the plant variety protection law. And this is actually the bone of contention. And, in certain cases which are now being fought, and we will not talk about it at this point of time, but this ambiguity needs to be resolved. Protection against infringement. I think there is a robust framework and enforcement of data protection for novel seed products. enforcement of the PVP laws against infringements at state level. I think so far 112 infringements in the last 15 years. So I think we can still do better. Interim protection of varieties and hybrids when applied at PVP till the time protection is granted. I think Dr. Trilochan Mahapatra spoke about it. So the interim protection is extremely important, and I think the PVP officials are actually working on it. The other last point is that the NBA approval to access seed packet to check infringement for Section 32 companies. Our prayer is that it should be actually waived off. So these are some of the recommendations on behalf of the seed industry FSAI, which we think that while we have progressed well in the last few years, but I think much more needs to be done given our ambition and aspirations to be where we want to be in terms of either a big exporter or in terms of taking the Indian seed industry to a $20 billion level. So more effective implementation, ambiguity between patents and plant variety protection laws, and then the protection against infringement. Policy and regulatory environment, we always speak about that need for reforms for a stable, predictable, transparent, and a science-based policy and regulatory environment. Alignment between a union and state agriculture policies. This also is an extremely important one. IPR protection, balance between open access to genetic resources and then the protection of intellectual property. And then pending legislations which are there, which I think the earlier speakers have also alluded about, especially the seed bill, the BRA bill. BRA bill is almost there now. I think they all should also be enacted in a timely manner to clear line of sight for introduction of new products and technologies. So this is, just a perspective about what the Indian seed industry is, where it wants to go, and what are their recommendations to ensure that the existing PPV FRA and the IPR this thing is strengthened. So I hope against this perspective, we all will have good conversations and also look at the best practices from some of our dignitaries who are speaking from outside of India. Thank you so much.
Thank you so much, sir. Ladies and gentlemen, please join me in welcoming Dr. Dinesh Agarwal, Registrar General, Protection of Plant Varieties and Farmers' Rights Authority, PPVFRA, Government of India. Doctor will be delivering a special address on India's plant variety protection law. Please join me in extending a warm welcome to you. Over to you, sir.
So Mr. Ajay Rana, President, Federation of Seed Industry of India, Mr. Raghav Sampath Kumar, Executive Director, FSII, my fellow speakers, and present among the audience, Dr. Vasal Sahab, Dr. H.S. Gupta Sahab, Dr. K.C. Bansal Sahab, and all of the seniors, and my colleagues from PPVFR Authority, and the faculty and students from National Law University. So good afternoon to all of you, and I welcome you being a partner of this event. I welcome you to this event. In fact, we have been planning to host a session in collaboration, in association with FSII for a long time, because Dr. Raghav Sampath Kumar was talking about enforcement, and continuously we were getting this thing, that enforcement part, particularly when they approach police or judiciary, that awareness doesn't happen to be there. And the seat capital of India in Hyderabad, if they go to police and all, in Hyderabadi lingo, they would say, क्या बैंगन का बाता कर रहे हैं? बैंगन का बाता कर रहे हैं मतलब क्या फिजूल की बात कर रहे हैं? आप बैंगन की चोरी की बात कर रहे हैं? आप मिर्ची की चोरी की बात कर रहे हैं? So we thought of holding one session, one sensitization session there in Hyderabad, but because of election, it couldn't happen. But surely we would be doing it very soon. So thank you very much for organizing this program and inviting us so that we can talk to all the stakeholders. Thank you once again. And when the term IPR that comes to the mind, when we talk about IPR, the very term which comes to the mind is exclusivity, isn't it? So in the present era of exclusivity, when whatever act is being done or every word that is spoken, I mean, it falls within the realm of IPR. And I run a very high risk of committing an infringement. And like they say that one of the modern cardinal sin is that thou shall not be banal. You would not be repetitive. And I run a very high risk of committing it. and I plead guilty. I'm in company of liars. I plead guilty, mea culpa. And surely it is going to happen, and that is bound to happen, particularly when you are going to speak after the two doyens of agriculture sciences, Dr. Paroda Sahab and Dr. Mahapatra. It is bound to happen that you be imbibing some of the thoughts, some of their sentences. So that may happen. But anyway, I'll be talking to you about the plant variety protection, the topic that has been given to me that I should talk to you about the plant variety protection law in the country. And the first thing again, like as I said, that the National Law University students and the Federation of Seed Industry partner companies, they all are aware, they are all stakeholders, they have filed multiple applications with us for the protection of their plant varieties. So again, it would be like preaching to the converteds. Probably I'll be wasting my resources. Everyone is aware. So it would be very much like preaching to the converteds. But anyhow, I'll start. A couple of days ago, we celebrated the World IP Day at PPVFRA. Dr. Padma Bhushan, Dr. R.S. Paroda Sahab was the chief guest. So when we talk about the innovation, this year's theme was about the SDGs and innovation. So when we talk about innovation, this morning, Mr. Rana Sahab was talking about that our earlier tradition. I mean, India has been a land. He was talking about Charak. He was talking about, probably he forgot to mention Hakim Lukman, which again was a big name for Unani medicine. And those people really, number of innovations, number of things are, they go with their name. So when we talk of science, when we talk of research, the thing is, I would be quoting the eminent German philosopher of 18th century, Immanuel Kant. You might have heard his name, who said that science without practice is empty, and practice without science is simply null. So when we talk of innovation, whatever we do, when we invent something, and if it doesn't find a place in our day-to-day practice, it is going to be a waste. And how it would find a place in our day-to-day activities is if we are able to provide it a proper protection. That is where we come to the picture. So, and if we talk of IPR, its relation with the food and agriculture, I tell you that it goes back long back. In 6th century, I am talking about before Christ, in ancient Greece, that area was Sybaris. They say the bakers, they were given exclusivity for their culinary preparations, for their bread. So in a way, in a word of speaking, it can be said that the rising of bread has a relation with the rising of IPR in food and agriculture. So that it goes a long way. It goes a long way. So now if I can start, next slide, please. Can I have the next slide? Oh, it's here only. Yeah, thank you. It's not working. आप वहां से चेंज कर दीजिए. It's not working. आप वहां से चेंज कर दीजिए. Yeah, that's what, sir. I'm pressing the side one. Yeah, now it's there. Yeah. So when I told you that the relation of IPR with the food and agriculture that goes long back, and this in this modern era, when we talk about the exclusivity, again I would be quoting from our ancient scripture, that is the Brahadakaranya Upanishad, that again is somewhere from 5th to 6th century before Christ, and it talks about the inclusion. This morning also, Dr. Mahapatra Sahab, probably Rana Sahab was talking about Sarjan Hitai, Sarjan Sukhai. So this is our ancient Indian philosophy. Sarve Bhavantu Sukhina, Sarve Santu Niramaya, Sarve Bhadrani Pashyantu, Ma Kashchit Dukh Bhagvet. So our theory, our philosophy has always been of inclusion, of including everyone, thinking about everyone's welfare, thinking about everyone's benefit. So, but we are living in the modern world. And when we signed WTO in 1992, this morning also speakers were talking about that how it was mandatory for us to implement the plant breeders' rights in our country, particularly when we signed the TRIPS and WTO agreement. So we enacted, our parliament enacted our act, PPVFR Act in 2001, and rules were framed in 2003, and this authority came into being in 2005. as I told you, so when this authority was established, in fact, we started our business in 2006. You would probably be aware. I mean, of course, all the stakeholders from FSII would be knowing it. But for the students, those who have come from National Law University, before we grant plant variety protection to any variety in a crop species, the first and foremost requirement is we have to develop the DUS test guidelines, because when we grant PVP protection, it happens to be based on criteria of distinctiveness, uniformity, and stability. So to test the distinctiveness, whatever exists in the common knowledge, whatever exists in the public domain, we have to have the rules of the game. So for that only, we developed in 2006, for the first time, we developed the DUS test guidelines for 12 crop species, and first set of certificates were granted in 2007. And in fact, among all IPR registries, ours is quite young. Last year only we completed 18 years of our existence. We are still revising. We are still work in progress kind of thing. The way we have revised our so many things, probably you have experienced also. At times it happens to be at the behest of industry. At times it happens to be behest of other stakeholders. So we are revising ourselves. We are reinventing ourselves all the time. This morning, Chairperson PPVFRA, he was talking about, in fact, Dr. Paroda also spoke about this. So when we chose this sui generis system, why did we do so? Because when we adopted this PPVFR Act, we did a lot of balancing act, because our agriculture scenario is altogether different than how it is in Europe, how it is in America. Because our seed sector, basically it comprises of two things, formal and informal seed sector. So when this law came into being, most of our seed supply used to be through informal seed sector, where farmers would be exchanging the seeds, they would be selling among themselves. So, and the share of formal seed sector, where public sector institutions like ICAR or state agriculture universities or private seed industry, their share really used to be very small. So when we brought this system, we had to take into consideration the average landholding size of our farmers, the prevalent seed system which was there in the country, and most importantly, if I go to the next slide, our country, I mean, nature has bestowed us with so much of native biodiversity. Rice is our own crop, mango is our own crop, brinjal is our own crop. So we have, for so many crops, we have tremendous agro biodiversity available, and our farmers have preserved and conserved that agro biodiversity for centuries altogether. They have made it available to modern breeding programs. So it was imperative on us that we have to safeguard their interests. So that is how, when India, under the WTO, when we signed WTO and we brought in a sui generis system of our own, we took care of these points. And despite having, again, I'll tell you, I'll reiterate this point, despite having a very extensive set of rights available to farmers in our act, our seed industry, that is the fifth largest in the country, and probably it is growing at a rate of cumulative annual growth rate of 12%. Maybe in a couple of years of time, that could be number 3 in the world. So despite having such extensive set of farmers' rights available, our seed industry is a thriving one. That's what I want to tell you. And how now this slide shows you what role PPVFR plays, because this morning Dr. Mahapatra was telling, so when this authority was established, one of the objectives was to promote the innovation, so that there would be investment in R&D in seed sectors, and our farmers would be having basket of choices in terms of number of varieties, so that our agriculture productivity would go up. And once agriculture production and productivity goes up, that would ensure country's food and nutritional security. So this is the slide that shows you how PPVFR, of course, we are protecting IPR of public sector institutions and private sector, which again enhances the investment in R&D. This morning, somebody was talking about the investment in R&D. I think still by global standards, we are lagging behind. I think for global seed companies, it is somewhere around 12 to 15%. And for our Indian seed sector, that happens to be something around 2 to 5%. So that's what I read it somewhere. Maybe the figure, maybe you would be in a better position to tell me. So, but still, if you want to take it to the global standards, where 12 to 15% of total turnover is invested into R&D, we have to have a robust IPR protection system. Of course, there are still, we have to go a long way to make it further robust. We are working on it. And apart from that, Dr. Paradasa was talking that farmers' varieties, that again is a very important component of our IPR repertoire. The total number of plant variety certificate that we have granted in these 18 years, that it stands somewhere around 7,100, and half of it belongs to farmers varieties, because our farmers, there are many farmers varieties, I mean, which are very popular, which are very famous. In fact, if you go to a metro like Bangalore, people would be demanding for Rajamudi rice, because that used to be the preferred rice of royal families. So there are many farmers varieties for which there is a huge demand, and they have made it available. They have made it available to public sector institutions, even to private sector companies for further breeding programs. So objective of PPVFR Act, you all know. The basic thing is when we signed WTO, we had to bring in a system where we would be safeguarding plant breeders' rights. And then again, as I told you, the contributions that our farmers have made, we had this obligation also to save their rights. We had to promote the investment in R&D, particularly for seed sector. And once there happens to be investment in R&D, farmers would be getting basket of choices in terms of varieties. So this, I don't think I have to tell you. You all are aware that PPVFR Act, like all other, it could be UPOV and all, everywhere, these sets of rights are available. That's a researcher's rights, where a person is free to use. I mean, for innovation, even if a variety is protected, there is no restriction on single-time use. If one wants to use a protected variety under the repeated use, like in a repeated backcrossing breeding program, or it could be for the development of a hybrid, then the authorization is required. And then, of course, there is breeders' rights. You all know about it. And farmers' rights, I'll be talking to you. So plant breeders' rights, these basically they include rights to produce, to sell, to market, to distribute, to import, and to export. These are the exclusive rights that are given to plant breeders. Researchers' rights, as I told you, that use of any registered varieties for conducting experimental research, use of variety as an initial source of variety for the purpose of creation of other varieties. There is no restriction, no authorization, no permission is required for single-time use. And farmers' rights. This morning, I mean, you all know, and at times, Mr. Rana was talking about that when they discuss it in their boardrooms, particularly for multinational companies, they say that there is a lot of leakage, there is a lot of pilferage here, but still considering the size of market here, they don't bother much about it. But I tell you that most of these farmers' rights, when we say that in India we have an extensive set of farmers' rights, they are there in other IPR legislation also. In UPO also, like if you see CPVO or the other countries which are following UPO, for example, Brazil, they also have. I mean, apart from new varieties, one can register varieties which are in existence for 10 years. Even farmers also, they have this right available to them that they can save their own seed. And small farmers, and their definition of a small farmers and our definition of a small farmers, there would be huge difference even in CPVO. In case of cereals, a farmer can save up to 92 quintals of his produce as a seed. So that's a huge quantum. That's a huge quantum. So I think it's a kind of fallacy if we say that in our country only farmers they have this extensive set of rights, and other things like benefit sharing or compensation. It is there everywhere. And in some ways, like if you talk of Brazil, the total period of production, of course, UPO talks about the 20 and 25 years. In case of Brazil, it is 15 and 18 years. And there is a special provision they call restricted use. It's up to the national government, it's up to the federal government. If they want to take, even if it happens to be from private sector, they can use that variety for 3 years without seeking any authorization, without making any payment. So those kind of things are there. Similarly, if I talk about South Africa, which follows UPOV, there is a provision. I mean, here you'd be getting protection for 15 and 18 years. There, the sole protection, sole authorization happens to be just for 5 and 7 years. Beyond 5 and 7 years, you have to license to others. So there are certain beauties in this thing, and it would be a fallacy if we say that because of, farmers' rights, there is a pilferage, there is a leakage. Of course, we have to safeguard our farmers' interests also, particularly keeping in mind the contribution they have made, particularly keeping in mind their economic condition, particularly keeping in mind, the kind of awareness they have towards their rights. So you would be knowing for students, of course, my seed industry friends, they know that what and all are registrable under our act. So in apart from new varieties, like in case of UPOV, it would be registering only new varieties of plants. In our case, we recognize the extant varieties also. And in extant varieties, there are varieties which have been released. We call those released and notified varieties under the Seed Act 1966. Many times private sector also they contribute for ICRP trials and their varieties are also notified. So we register those varieties also as a special category where we do not do any separate DUS test. Even the fee happens to be minimal. And in fact, I mean, when we enacted this law, I mean, this provision was available only for a limited period of time. Last year, we constituted a committee under the chairmanship of Dr. Paroda, and the time limit for filing of application for extra notified varieties has been extended by another 10 years. So it is available to all, to public sector as well as to private sector. If you could not register some of the varieties which have been commercialized more than a year ago, those could still be registered as the varieties of common knowledge. So if some people from industry, they are not aware of this fact, I would request them. We have extended the time limit by another 10 years, so you can register those varieties of common knowledge now. Then, as I already told you, the criteria for grant of plant variety protection in case of new varieties, it happens to be novelty, distinctiveness, uniformity, and stability. And for the extant varieties, apart from novelty, all the three criteria we follow. All of the three criteria we follow. I'll share this presentation with you so that, of course, you would be knowing or that what do we mean by distinctiveness and how uniformity is ascertained and what do we mean by stability, those things. So duration of protection, as I was telling you, in case of UPO, it happens to be 15 and 18 years. In case of UPO, it happens to be 20 years for agricultural species, and for tree and vine, it happens to be 25 years. But the Europe, the Community Plant Variety Office, there the period of protection would be 25 and 30 years. Some of the countries which follow UPO, like Brazil, I was talking about, they follow 15 and 18 years, and that 15 years, it includes even the period of provisional protection. In our system, we grant you protection from the date of grant of certificate. In case of Brazil, it happens to be 15 years only. Of course, it follows UPO, but the period of protection happens to be 15 years, which happens to be inclusive of even provisional protection. So already, I mean, previous speaker has also he has shown this slide that so far we have received more than 18,000 applications in these 18 years, and we have issued more than 7,000 certificates. And another interesting fact I would like to share with you, of course, in terms of number of certificates that are being granted, in last 18 years, so far we have granted only 7,000. But out of those 7,000, 2,000 certificates have been granted during last 1 year. And in terms of sheer numbers, if you see the number of certificates that have been granted in 1 year, at this moment, as an individual country, we stand on the second position in the world. Of course, China is number one, and in a way they are 1 to 10, because they, for last 3-4 years, every year on an average, they are registering 10 to 11,000 varieties. In last 1 year, we registered nearly 2,000 varieties. In case of CPVO, that's a Community Plant Variety Office for European Union, as a 27-member body, they registered nearly 3,500 varieties in a year. In US, where apart from plant variety protection, there are multiple options available like patent or utility patent. But if you see the plant variety PVPO office, their number stands somewhere around 600, 650. Same goes for Australia. In case of Brazil, it would be still much lesser than that. So now, as far as PPVFR is concerned, I want to assure you that we are also trying our level best to bring down the pendency, and the 2,000 certificate that we have granted in last 1 year, that bears testimony to that. We still want to reduce pendency by this year. Because there are, I accept that there are number of applications which are pending for last 10 years that happened because of certain changes which we brought in between, like compound registration, and industry has been demanding that to withdraw that, and last year we have withdrawn the compound registration. I think that has removed a major difficulty. And apart from that, we have extended the time limit for registration of varieties of common knowledge or registration of notified varieties under Seed Act 1966. Dr. Mahapatra sir was talking another thing that is about the provisional protection. In fact, in our act, the provisional protection has been defined just in 3.5 lines. So enabling provisions are not there in rules that were framed by Government of India. Now we have constituted a committee under the chairmanship of Dr. H.S. Gupta Sahab, and we are taking the good points which happen to be available elsewhere, like it could be in CPVO, or it is from Singapore, or it is from Australia, and we want to bring in that system. So we are addressing it. Maybe in 3 months' time, as Dr. Mahapatra Sahab said, that system would be in place. That is one thing. And another thing, this morning again I am repeating that thing, is like so far our DOS characteristics. How do we register a variety? When you give us an application, when you submit an application, there happen to be a technical questionnaire where you would be filling the data based on our DOS guidelines. And apart from that, the modern breeding programs are all about quality, all about resistance features. You would be mentioning, but we do not have any way of testing your variety for that special feature. Now again, we have constituted a committee under the former Deputy Director General of ICAR, Dr. Swapan Dattaji, to include those special traits also. So suppose if you have a variety with a better nutritional profile and you want to get it registered for that, so we are going to include those characters also. So that also is going to be there, and already 2 meetings have happened, and maybe in 3-4 months time that again is going to be happen. And another area of concern is of course, as I told you, that ours is the youngest registry. If you see it globally also, only 18 years of existence. If we compare the number of crop species that are available in case of UPO, number stands somewhere around 338. And if we take CPVO, that's a Community Plant Variety Office, again they have DOS guidelines available for some 200 odd species. And in addition to that, they have this advantage there where the national offices are there. Like in case of Netherlands, it would be Nectinbo. In case of Germany, it would be Bundessortenum. So they would be having, few more guidelines available to them. So total number happens to be somewhere around 2,500. In case of India, so far we have developed the DOS guidelines for 197 crop species. As I told you, as per our act, if you want to register a new variety in a crop species, the first and foremost requirement is the DOS guideline should be in place. So now we have constituted a committee under the chairmanship of former Director General ICR, Dr. Mangla Rai Saha, and we have already taken up this task so as to identify those crop species where so far DOS guidelines are not available. We are working on that, and many of our DOS guidelines were developed nearly 1.5 decade ago. And there is because nothing is sacrosanct, everything changes with the time. So even for the revision of those DOS test guidelines which were made some 2 decades ago, we have constituted a committee and we are working on that. So that is one area that again we are, and in a way we want to create an environment. Our honorable Prime Minister, all the time he talks about ease of doing business. So we also want to facilitate you in all the way. There should be minimum pendency. If you submit your an application well in time and complete in all aspects, we also want to expedite the registration process. That much we want to assure you. And apart from that, Dr. This morning, Chairperson sir was talking about. Morning, Sampatji was giving an example of South Korea. Why number of applications are more? Why number of certificates are being issued? That happens to be highest because of enforcement, effective enforcement. Of course, enforcement, provision for effective enforcement is there in Act. But at times, what I believe is it is more of self-regulation, isn't it? Like many times your own constituent members, if they are able to resolve dispute, they don't have to come to us. Of course, their attorneys are sitting. I don't want to comment anything, but mostly it would be just those proceedings would go on. Attorneys would come and all the time they would pick those holes which do not happen to be technical by nature. I mean, they would be taking shelter behind all the legalities and all, and that would keep on prolonging. And what happens in the process? It is us who get a bad name, that authority is not resolving this dispute, but actually that happens to be between attorneys. So why not, like, international seed federation and all, like, it is a high time, even FSII or NSAI, you can think of self regulation, particularly for EDVs. There is a provision now in our act. It is the authority which decides if a variety is an EDV or not. It doesn't happen to be like that in UPOF. It is up to the companies, they have to decide. And by the way, I would like to inform that is one area which I forgot to mention. Now, EDVs also, as you are aware, that Government of India has taken out, I mean, in case of genome editing, particularly two segments, SDN1 and SDN2, out of the realm of GMOs. So there could be, we are expecting there could be more number of cases in terms of EDVs. So we have to go behind, I mean, go beyond the way we have been dealing with the EDVs, particularly in terms of genetic similarity, how it is being done elsewhere. So we have constituted one committee for that also. That also we are considering. So we are going to come out with the guidelines, particularly for the determination of EDV. That is one area. As I told you, for self-regulation, that is a really a big requirement. I hope that FSII would take a good note of it. That is one thing. Second thing is about the sensitization. Of course, after election, we would be doing it. And from authority side, we are making all our efforts. We have two legal advisors on our payroll, and we depute them from time to time to the different judicial academies and to other places also to sensitize the law enforcers about the PPVFR Act. And the third thing, again, now I'm here to, I'll make an appeal to you. Like when you register a variety with us, about its maintenance cost. At times we would be receiving a lump sum money from company without submitting the annual return. I mean the return form for annual fee, for renewal fee. And Mr. Surya Rao is smiling, and I don't want to take any company's name, but there are multiple. There are multiple, and that happens to be difficult for us also, because when audit comes to us, they would be asking that from where this money has come, and we would not have anything to tell. So please take care, like whenever you are submitting annual fee, renewal fee, please do submit the annual or renewal return form also, so that we would be knowing that the money that you have paid, that pertains to which particular variety in a crop. So thank you very much. With these words, thank you once again. I convey my thanks to FSIL. Thank you.
Thank you so much, sir. May I please request Mr. Raghavan Sampath Kumar to do the. Sure, sir.
I was talking about facilitation and the number of initiatives that we have taken. I have already informed you. And I, for one, I do not take myself as a registrar general. I always believe I'm facilitator general. I am here. I'm being paid to facilitate the registration. And the way, the kind of ease of doing business, that thing that we are trying to create in PPVFR. Of course, in coming months, you would be seeing number of ways how we are doing it. And if I have to equate it, I mean, the term that comes to my mind is, I would give it in parlance of aviation industry. The term is CAVU. That stands for Ceiling and Visibility Unlimited. So every time a pilot takes off from a airstrip, he longs to hear that word from air traffic controller, ceiling and visibility unlimited, CAVU, that the conditions are perfect for flying. So we want to create those perfect conditions for flying. Thank you. Thank you very much.
Thank you so much, sir. May I please request Mr. Raghavan Sampath Kumar to do the honors and offer a small token of appreciation to Dr. Dinesh Agarwal, please. Thank you so much, sir. We are honored to have with us Ms. Samsravi Shrain, Director, India Agri Arbitration Center Advocate, Supreme Court of India. May I please request Dr. Ratna Kumria to do the honors in welcoming Ms. Samsravi Shrain with a small token of appreciation, please. Thank you so much, ma'am. Joining us virtually from Singapore, we have the honor of hosting Dr. Siangi Tan, Executive Director of CropLife Asia, for a special address on the plant science industry's perspective on IP. Sir, the stage is all yours.
Thank you. Good afternoon, everyone. Thank you for having me here today. Am I audible and can you see my slides?
Yes, sir. Yes.
Thank you. So again, there's a series of very good speakers before me and a lot of clear articulation about the aspiration for India's seat, which I'm really happy to hear, and especially India becoming a supporting farmer for doubling of income and etc. So let me share with you some of the work that we as the industry are supporting India. And again, I work for CropLife Asia, based in Singapore, managing 15 countries across Asia Pacific. CropLife International is a federation of the plant science industry. We have 91 offices across the world. And in Asia itself, CropLife India, for example, and FSII, our colleagues in both CP, biotech, and seeds agenda. And our members are BASF, Bayer, Corteva, FMC, Syngenta, Sumitomo. And we have an associate member, Simprot, that does on potato. The figures beside that is, sorry, I cannot get into crores decimal, but this is the annual investment that our members put collectively in R&D for seeds and biotech. So it shows that how much we are committed to deliver technology into the hands of farmer. And as all mentioned, the seed takes a long time to develop, and with a lot of traits that we need to develop also because of the challenges that we foresee. So for CropLife, we work in the area of crop protection, delivering technology innovation to the hands of farmers, plant biotech and seed. We also work on stewardship and responsible use. Every year, we train about 1 million farmers across Asia, and annually, we train about 25 million farmers across the world. And today, you also heard about anti-counterfeiting. Today, the seeds issue is also being counterfeited, especially brown bags. We're seeing more and more high percentage of illegal seeds, and who will suffer? Farmers that are unaware of illegal seeds, brown bag seeds are suffering, and their crops and nothing grows in their farm. We're seeing, for example, China last couple of years seized 34 metric tons, 34,000 kilograms of illegal seeds. And every year there are a lot of anti-counterfeit programs against illegal ships and partnership across the region to ensure that we speak to our different stakeholders so that we ensure that we continue to advocate for the agriculture industry and the key issues. So collectively, the global challenge of plant breeding, as you're aware today, we're seeing high temperatures across the region, but that brings other complications, whether it's drought resistance, whether it's drought tolerance, disease tolerance, and also many other emerging diseases like locusts that we are seeing coming out. So the plant unfortunately takes longer time to adapt to an environment, and therefore the fastening or the hastening of our plant breeding technology is one of the key what you call solution to it, and most importantly producing more with less environmental footprint. So a lot of challenges for us to address in the future, but more importantly, how do we continue to feed sustainably into a growing population? So with that, the farming we want just now, our especially what you call our excellency before that was our secretary ICAR, Dr. R.S. Peroda. What do we want for the future of farming? Again, respond to the challenges of expanding population, satisfying demand for growth and affluence, plant science industry is to continue to commit to play a vital role to delivering technology, putting the technology into the hands of farmer. And today, the PVP discussion and etc. are very, very crucial to ensure that we continue to have license to operate under smart regulations, socially responsible for a sustainable approach for security. So no matter where we are, no matter how innovation moves, seed is going to be core. We can talk about it, whether it's safe, farm safe seed, whether it's open pollinated, etc. Until we get the correct seed material, our farmers will not be able to benefit to grow sustainably. So despite you talk about digital act and etc., from the onset, if the seeds is not correct, we will not be able to get the farmers to harvest. So we spoke about smallholder farming. We spoke about farm safe seed, etc. I just want to share with you, farmers are very, very smart, adaptive, and they know where they need to invest. So I just want to share with you, you spoke a lot about smallholder. India is also smallholder, but you look at the rate of adoption of hybrid seeds into the marketplace right now, it is almost 100% are all hybrid corn. And now they are also starting to look at plant breeding innovation, genome editing. The minister just recently said, I'm really so happy to hear Minister Thomas has said TBI rice will be out in the market and we'll see the SDN1, SDN2. But again, what I want to share with you is farmers are really keen to adopt technology. Even small countries like Singapore is investing in seed technology because they know seed security is important. They need to improve different traits for the domestic cultivation. We have invested a lot in vertical agriculture, looking at different technology. But just for a small country like this, we import 94% of our food, but yet we are cognizant on importance of seed technology. So with that, over the years, from time immemorial, we spoke about it, from Teosinte until today, it is all innovation led to produce better crops, better yield, and better productivity using less resources. That is where we are to increase position to tolerate to disease resistance. So moving forward, this a lot of investment has gone into it. Therefore, we need to ensure that IP makes innovation possible, improves our daily life, improves our farmers' uptake of technology, improves their ability to sell better products. I'll show with you what I did last time. And IP helps farmers to grow. Again, with better seeds is what you see in Thailand, for example, the adaptation of IP hybrid seeds that enable them to grow more with a hybrid what you call genetics that allows them to quantum leap in their yield. So correctly before just now our speaker has said PV protection and also innovation and also what you call access to breeder exemption all needs to have a balance. And how do we balance within that? Not to overstep, ensure that technology is available for everyone and to benefit the farming community. Sorry about that. So I just want to share with you tobacco mosaic virus. All of you are very, very familiar. First identified in 1806, and only in 1992 we were able to identify the disease-resistant gene, and that is 100 years just to identify the disease-resistant gene. And it was in my lab in Japan that we managed to look at it, and that became a scar marker for us to do breeding across many, many crops in tomato and etc. It's a very damaging crop. So R&D technology takes time and investment. Everybody likes Japanese melon. This was, until today, people are amazed by why one melon can sell for $20 or $30. So this was also a part of my lab work last time. It was infected by virus. The industry almost collapsed because the fruits were not sellable. So what we did, we screened through a series of about 45,000 isolates to develop an attenuated virus that we could protect the plants. At the end, this was year 1985 when we first developed it. and then continue to bring on. But again, R&D going to market to help farmer to utilize it. And again, we were able to save, and today we are still enjoying a lot of melons that is coming up. What I'm trying to say is farmer needs technology, farmer needs help. There are different technology that will benefit the community, and it's a lot of investment going in. So that's where I'm trying to say to you is collectively our member company invest a lot of money to bring technology into the hand farmers, especially on the GM trade. $100 million and takes us 16.5 years. I just want to give you that context when we first started with TMV, 100 years. But now, because of innovation and speed, we can bring technology, we can bring products to the market fast at a much more faster pace. Of course, time to market because of regulatory environment. So this is where I'm trying to share with you, the time to go to market has now increased from 13 years to now 16.2 years. And the cost has come down slightly because more and more countries are more familiar with the trades. We are getting a lot of exemptions or reduced in dossier. But again, this is how science has moved. Provision, we are getting more and more products into the market, and also be able to look at shorter time. Hopefully, we can reduce the time to bring products into the market. And I really see that India has quantum leap with the SDN1, SDN2, and you're going to be a much more bigger player in terms of bringing newer technology, newer trades, faster trades to the hands of farmer in a shorter time. So what's it taking so long? So from an R&D, 53 over months, and look at how much we go through regulatory, 200 over months just to get a regulatory process through to the marketplace, and 142 months for the genetic construct and testing market. As you know, all our products are market tested for reliability and etc. Going back to the hybrid context, if we continue to promote farm safe seed, I'll give you an example of Cambodia. We have about 40 over farm safe seed variety on the ground. But because of farm safe seed, because of the inbreeding, everybody is growing millets small as opposed to rice, and it becomes non-exportable, and locally no one buys them anymore. So you need to balance what is beneficial for smallholder, but to what generation you want to farm safe seed it, and to what you're being able to market the farmer produce. So this is an open, you can check, and then the varieties are so small, and people are still using what you call marine type of sunken rice cultivation at 1 metric ton per hectare. Today, in many places, we are averaging of 10 to 15 metric ton. And just now we spoke about hybrid rice. Many people have already utilizing new varieties. So we need to be very careful what you promote, farm safe seeds, to what extent that it doesn't become a hybrid velocity that is decreasing, that does not give you the benefit of growth and ability to produce good quality product so that you can go to market. Then again, what is the innovation in the back? As I mentioned, no matter what technology, digital act, and etc., the fundamental starts with good seed quality, breeding good genetics, advanced technology for selection and breeding. Seed treatment is also cost. A lot of people don't realize that by coating the seed actually save more than 50% on the day itself. When insects come to attack overnight, a lot of people have not embraced the importance of seed technology. Then, of course, the crop protection product, and then the post-harvest to ensure that their produce that are grown, taken time, be able to get the harvest and the sales price that they need. And then the services of the cultivation. Today we have digital act, and our member companies have committed to invest euro 10 billion for the next 10 years to bring digital act into the hands of farmers. And then with that, there are different mapping, looking at soil moisture, looking at soil fertility, optimization of cultivation, and then planning for the next season. A lot of things have to be there, but then behind it is to deploy breeding technology, to look at new breed varieties, to develop biotech traits. It can be both GMO and also plant breeding innovation. And today we are one of the largest companies group that produces gene editing products in the marketplace. So again, genome editing is a toolbox that allows us to do many things in a much more faster pace to improve variety, to develop elite lines that we are putting into the market. Again, today you have covered a lot of the PBR, the PVP for germplasm, patents of it in terms of trade, novelty, incentives, stepwise implication, trademark, contract, trade secret, and etc. I think you have covered it very clearly today by the a few other speakers. But most importantly, we need to ensure that the varieties that are put in the farm place is protected so that we all can continue to reinvest to bring new varieties into the marketplace. The caveat is to ensure the farmers have the best productivity, the best genetics that allows them to grow under the different situations they are in. Farmers are very well trained. They know which environment they need. For example, we have a plant breeding innovation product for drought resistance that will, under drought situation, can still perform at 5 to 6% above compared to the drought plants that are non-gene edited. So there are different pieces in the ground with with longer shelf life and etc., which we can talk a bit more later. So the patents itself, it's the most granted, repeatable. I think just now we spoke about who has been patenting more. And then the gene sequence of usually is very important also. And today we spoke more about plant variety that we are very focused on with PVP and breeder trait. But nevertheless, there are different type of patents that relates to the plant variety also. So regulatory status and patentability are governed by separate legislation. There are two distinct legal frameworks that helps protect human, animal health, and to the environment. The IP patent system is designed to stimulate innovation in all field technology, whether products that does not fall under regulatory framework for biotechnology has no bearing on patentability of such products. So we need to be very careful whether it's patentable and etc. So very closely with the regulatory environment, but nevertheless, the IP patent system stimulates innovation for us to reinvest into developing better products into the market. So US has also looked at this. They are now expanded intellectual property to protect crop seeds, increase innovation and market power for companies. Again, bringing new resources in so that we continue to bring products into the marketplace at a faster pace. And we're seeing this much more with the genome editing piece. But nevertheless, we continue to focus on the genome, the GMO piece also to continue to make sure that we give farmers the newer stacks that we are generating, whether it's on insect tolerance also. So there are various combinations that's coming through the marketplace. We have a very strong pipeline that is produced by our member companies. So coming to almost the last few slides, support intellectual property regime, and we are very favorable and look at where India is, and we continue to encourage all governments to become UPOF. Even Vietnam, as an agriculture country, has also adopted UPOF 1991. We are here to support capacity building, include sharing best practice, know-how, risk communication, intergovernment office discussion, a G2G basis. Whether it's Raghavan said, talk about his APSA meeting, and many other things that we could work with you, with seed association, farmer group in shaping policies and taking action, especially on the illegal and unauthorized seeds, because we are seeing more and more smallholder farmers suffering. And especially right now, we are seeing a lot of illegal seeds are sold on e-commerce. This one is a separate topic we want to talk about, but nevertheless, we are seeing a lot of this situation, and we are working very closely with e-commerce platform to try to stop this and destroying the agriculture. So advocacy on government, important industry, on what they call CBD Convention, Kyoto Nagoya Protocol on genetic resources, fair and equitable sharing of benefit arising from utilization, Kuala Nagoya Protocol on liability and redress, so global presence. So there are many things that we are working on collectively to ensure that the global community continues to be able to trade open border. And just now I mentioned, you talk about DUS. DUS is core. And we are also working on e-phytosanitary to ensure that our seeds, whether it's India and etc., could move beyond borders because we have different location of seed production hub For example, Thailand sits in Chiang Mai, Chiang Rai at the core. We are seeing also Philippines in India becoming seed production hub. Also, Australia becomes some of the production hub for seed. So, getting a mutual recognition of phytosanitary is a part of our work that we have in CropLife Asia domain. With that, a short introduction of where we are, where the scenario is, and why we invest and continue to focus on driving and deliver new seeds product into the hands of farmers. Thank you, Raghavan, and thank you, FSII, for the opportunity.
Thank you so much, sir. To enlighten us with the best practices of anti-infringement, global best practices, we are happy to have Mr. Ignacio Giachi, Managing Director, Anti-Infringement Bureau for IP Rights on Plant Material, Brussels, Belgium, joining us online. Over to you, sir.
Hello, thank you very much for the presentation. Thank you everybody for showing up today. It's always a pleasure to join this kind of platforms where you have private sector and public sector coming together. Just one question of good order. Should I play the presentation or you're going to be showing it?
Sir, you may show the presentation, please.
Perfect. Okay. Can everybody see my screen? Just want to make sure everything's in order.
Yes, sir. Yes, sir.
Perfect. Thank you. Okay. I'm here today to present the work of the AIB. We're going to start with this introductory slides. The AIB is the Anti-Infringement Bureau for Intellectual Property Rights on Plant Material. We are an international non-profit association with headquarters in Brussels. We started operations in 2010, and membership to the association is open to integrated vegetable seed companies. Just for your information, this is basically the composition of our membership. I expect you'll be familiar with most of these names. What are the goals of the AIB? In the first place, is to fight illegal seed practices in the general interest of the industry. Illegal seed practices can be both private and public law offenses. A private law offense, PDR infringement, is a typical case. A public law offense would be, for example, an infringement of seed marketing regulations, when a company, for example, somehow manages to register in the catalog an existing protected variety under a different name. That's a very widespread practice. Number two, to improve the conditions for effective enforcement. The AIB does not really specialize in any lobbying activities, but whenever we identify a flaw in the legal framework of a certain country, we would communicate that with the local association or any other entity so that they can influence policymakers. Then number three is about raising awareness on intellectual property and illegal seed practices, and that's exactly what we're doing here today. Number four is about reducing the risk of infringements by securing the supply chain. Basically, what we have done over the years is to try and implement auditing scheme for example, seed conditioning companies or seed producing companies. We have a new auditing scheme for seed producers that we're beginning to implement in Europe and in Latin America. And these are great exercises because every year we can go to these companies and have access to the list of orders. For example, pelleting companies. We look at the companies and the material they have pelleted. We take samples, we have it tested, and very often we find infringements. For example, in 2023, we found that 9% of the pelleted material in Europe was infringing. So you can imagine the value of these tools is very, very significant. The AIB has global scope in principle, but we focus on the European Union, on Turkey, the Middle East, and North Africa. But we're open. If, for example, an opportunity arises in a different country, say India, for us to pursue an infringement case, if we consider that the chances of succeeding are high, we might pursue it. This has been a recurring topic throughout the conference today. We know that by 2050, the global population is expected to reach 9.7 billion. The figure often varies depending on the source, but it's pretty much around this figure. And we also know that the demand for food supplies will be 60% higher than it is today. But we have a problem. We have climate change, we have soil degradation, we have water shortages. So, and these factors are going to pose serious risks to our ability to produce food. So the question that we have to ask ourselves very seriously is, how can we achieve food security in this context? And we believe plant breeding is part of the solution. It's not the only solution, but it's certainly part of the solution. Okay, now let's take a look at the global picture of piracy. In 2019, according to the OECD, trade in counterfeit goods amounted to 464 billion. That is 2.5% of global trade. It's a significant percentage. We're learning that consumers are not always victims. For example, a study suggests that 54% of counterfeits in small parcels were bought knowingly by consumers. There is usually the conception that consumers are the victims, so we have to spend more time teaching consumers. But what we're finding is that consumers, more often than not, they know what they're doing, they know what they're buying. So it's not just about educating consumers. We have to really work with the public sector to intercept, to identify and detain the flow of counterfeit goods. Counterfeiting affects all sectors to different extents. It appears that the seed industry to this date has been unable to put a dollar figure to the revenue loss to IP infringement, and this is something we're working on. We want to know exactly how much revenue the sector is losing to IP infringements. And there's also an element of forced labor behind counterfeiting. So this is something authorities should always bear in mind. It's not just about enforcing or protecting the exclusive rights of breeders, for example. There's a cluster of illegalities behind BDR infringement, as we're going to see later on. Piracy is also helped by a number of factors. For example, the consolidation of e-commerce. 159 billion parcels were shipped in 2021. There is also pressure for rapid logistics, and we know that between 0.5 and 1% of containers are inspected, which means there's a 99% of containers that just go undetected. And there's also the fact that enforcement authorities lack the resources, the expertise, and awareness to fight IP infringement. And at the same time, we know that they have other priorities. Vegetable breeding is among the most research-intensive industries in the world, which makes it vulnerable to piracy. Especially in the vegetable seed sector, we know that many companies invest between 20 to 25% of their revenue in research and development. What are the vulnerabilities of the seed sector? Okay, nature is a perfect coping machine. And this is something you're not going to find in the luxury, in the technology, or in the auto parts industry. In our industry, nature is a perfect coping machine. We can see that perfectly when it comes to reproduction of open pollinated varieties. Also, coping is cheap and requires little capital investment. There is no distinction between legal and illegal harvested products. You pick up a tomato, you compare it I mean, assuming it was, for example, propagated vegetatively, you can never see the difference when you look at the harvested product, right? So that makes the work of enforcement authorities very, very challenging. Vegetable seeds are also very small volume, which means they're easy to transport. We know that there is a very significant flow of illegally reproduced seeds coming from Jordan, for example, going all the way to Egypt and then flooding North African markets. We know that effective enforcement of PVR is very, very challenging for reasons that we're going to be seeing later in the presentation. At the AIB, we're becoming very, very interested in exactly scoping out the extent of the problem. We want to know where we're having issues, what are the main crops affected. So in 2023, and we completed the activity in 2024, we conducted a survey jointly with Euroseed, which is the European Seed Association. We asked members a number of questions to understand whether they're having issues. And we established that the number of cases by crop placed tomato in the first place with the highest number of infringement cases, followed by lettuce, melon, tomato rootstock, which is usually tomato rootstock fraud, then onion, cucumber, okay, the list goes on. We were also able to understand the infringement cases by country. And if you look at the bottom, you'll see that Turkey is basically the first place with the largest number of cases, followed by Spain, Central Asia and the Caucasus, Italy, and India in the fifth place. Of course, this is relative. This is information or statistics created based on the information we got from members who responded to the survey. There were a significant number of members who didn't provide responses, so we have a partial overview. This isn't really a total overview of the situation. We always like to start with this clarification because you'll find that even senior marketing officers have a misconception about the scope of variety listing versus variety protection. So basically, selling vegetable seeds in many countries is subject to seed marketing regulations. And the theory sounds very good, right? Registration in the National Variety Catalog is required. The seed producer has to be certified, has to adhere to quality standards, and the original variety name has to be used. But the reality is very different. What we find is that seed marketing regulations are very rarely enforced. And the practice is very different. There are very weak monitoring systems. In Italy, for example, you'll find that illegally reproduced varieties are sold under different names. They usually use variety names from the 70s, which have become generic names. But when you pick up those samples and you do a DNA test, you'll find that it's actually a protected variety. There are also fraudulent substitution of reference samples and variety description. So basically, a company goes and they provide samples to the variety listing offices. They claim it's one variety. But if you have that variety tested, you'll find that it's actually something else. There's also the problem of very soft sanctions for offenders. So it's not really a strong deterrent, which means they will just carry on doing the same practice. So what protection do you get from registering your variety in the National Vegetable Catalog? Absolutely no protection, none at all. Catalog registration only gives the right to sell the variety. For many of you, this will be a very obvious concept, but you'll be surprised at the number of people who have this misconception. So we feel it's important to reinforce it. And also to remind that everybody may copy seeds of unprotected varieties if the proper variety name is used, quality standards are met, if it's a certified seed producer, and the name of the seed company that bred the variety is not used. So yes, ultimately, the main instruments of the industry to protect their innovation remains plant variety rights. Um, I would like to share with you a review of cases in Italy that we conducted for cases started between September 13 to December 2022. So we're talking about 9 years of practice in Italy. So we had a total of 72 cases, an average of 8 cases per year. Out of those 72 cases, 49 cases obtained an administrative sanction. Out of those 49 cases, 42 cases were transferred to criminal courts. The number of cases with a favorable sentence were only 3 cases. So it's a very, very low, you could call successful rate if you consider that a favorable sentence is your number one metric. In terms of cases by crop, lettuce at the first place with 51 cases, followed by tomato with 18 cases, and spinach with 3 cases. The source of this is the ICQRF. The ICQRF is basically the armed body within the Italian Ministry of Agriculture. So we had to ask ourselves, why so few favorable criminal sentences? And the conclusions that we drew was that criminal judges and prosecutors, they're not really knowledgeable on plant variety rights. Then official laboratories, they don't have official protocols for identifying varieties, especially when it comes to DNA tests. So there's always this lack of official protocols ends up in discussions about the number of markers required to determine whether a variety is a copy or is not a copy. And what we find is that the procedures are very lengthy. So in the end, what happens is that the criminal action is declared prescribed. Okay, we were saying earlier that favorable sentences is just one metric. And it's certainly one metric beyond our control. I wanted to be more positive about the experience, the past experience of the AIB in Italy. So I drew these conclusions. Okay, so yes, we've had very few criminal sentences, but 68% of our denouncements, they resulted in administrative sanctions. That meant monetary fines and seizure of material. In many cases, seizure of plants, right? 58% of those denouncements led to criminal prosecution. That means infringers were forced to attend hearings, they had to pay lawyers' fees and waste their time. Trust me, they don't want to waste their time. And most importantly, key authorities became proactive in conducting the inspection. We're talking about the ICQRF. Remember, this is a body within the Ministry of Agriculture, and also Carabinieri Agroalimentare, which is a branch of the Carabinieri, which specializes in agri-food issues. So ultimately, infringers stopped or reduced their illegal activities. Therefore, the conclusion of the EIB is that, yes, indeed, favorable sentences would be ideal. But as the industry works to improve the conditions for effective enforcement, we must keep the pressure on the market to contain the infringement problem. If we don't do this, illegal propagation is only going to grow. This is just an example of a case we had in 2022, where 5,000 tomato plants were ultimately seized and destroyed. But okay, this took place in Ragusa. Ragusa in Sicily is basically one of the largest fresh tomato producers in the European Union. Obviously, we had a PVP tomato variety, otherwise we would not have had a legal basis for taking action. It was a case of vegetative propagation by cuttings. The grower buys 5,000 seeds, and then they ask the plant raiser to reproduce a further 5,000 plants via cuttings. We became aware of this by one of our members who reported the activity, and then we filed a complaint with the ICQRF. The ICQRF launched an inspection, verified the regulatory breach, and notified the prosecutor. It's interesting because the grower claimed that the extra 5,000 plants were for personal use. and asked the prosecutor to destroy them. The prosecutor allowed the grower to have the 5,000 plants destroyed and advised the judge to close the case, invoking something called the particular triviality of the matter. So basically, to give you some insights, 5,000 plants equals 5,000 tons, 15 tons, or 3,000 bottles of tomato sauce. So it would be very difficult for someone to claim this was for personal use, unless they have a very, very large family, which is not really the case in Italy these days. Also, the particular triviality doctrine entails that the facts have been proven, but that these are not serious enough to have a criminal case. This is really a inconsistency in the system, because if you consider PBR to be a criminal crime, you cannot then say that it's not serious enough. If the law provides for criminal prosecution, the judges and the prosecutors would have an obligation to take the matter forward. But instead, what they did was to ignore regulations such as plant variety rights and unfair competition. This is just an example of the challenges we encounter in the European Union. So you can imagine in the European Union, where one should expect that the legal frameworks are fairly advanced, the level of protection should be high. But the reality shows that this is not always the case. And of course, the challenges become even more when we go to different jurisdictions outside the European Union. I was telling you earlier, when it comes to securing the supply chain, we have a auditing scheme for sea conditions. We're covering 2 countries, Spain and the Netherlands, and we're auditing 3 companies. In 2023, we collected 68 samples, and we confirmed 6 cases of infringement, which amounts to 9% of the material was proven to be illegal. It's a fairly high percentage. Okay, very briefly, I would like to talk about the main illegalities that we find in the vegetable sector. Vegetative propagation of grafted crops is at the first place, with tomato, watermelon, melon, and eggplant. In some countries, this is actually from a couple of years back, where the degree of vegetative propagation was actually higher. To this day, the number has decreased, but in the past, it was close to 20% in Spain and 40% in Italy for you can see for cherry tomatoes, for example. Yes, absolutely. Then, very quickly, how we know that the grafting of tomato plants works in this way, at least within the European Union. Italy and Spain, there are different practices in different jurisdictions. You go from your cultivar and your rootstock to grafted plants. Now, grafting facilitates 2 ways of illegal vegetative reproduction. We have illegal reproduction by cuttings, and we have illegal reproduction by keeping the beheaded cultivar. We call that stubs. Basically, the grower or the nursery would have the obligation to discard the stub, but instead they keep it, and they go from 1 seed to more than 1 plant, which is illegal. This is an illustration of stubs, and this is an illustration of cuttings. PBR does not only affect the breeder, tax authorities are also affected, because when you have undeclared vegetative propagation, what you have is undeclared sales of tomatoes. So the tax authority is also a victim. And also, the practice of vegetative propagation can be related to the spread of the pepino virus in Sicily, which started in 2008 and caused significant losses to farmers. So farmers initially saw this as a way to increase their profit, but in the end, they ended up supporting significant losses. Reproduction of seeds of open pollinated crops. It's so easy to do that it's very tempting for farmers to do this. And it affects mostly lettuce and beans. These are produced outside national regulated systems. The varieties are often mislabeled. And there are infringing networks involved. It's a very profitable business. This is a case of infringement of Ragspan's viola, which was illegally reproduced and then sold under different names. This is just very quickly how profitable it is when networks reproduce OPs. You see, you go from an investment of $61,000 to profits of $461. You can imagine it's so profitable that it's very tempting for farmers and nurseries to encourage this practice. F2 production of hybrids, basically affecting onions, spinach, and other crops. In this case, usually the yield is not so good, so farmers don't really have the incentive to incur. But in second tier and third tier countries, you'll see that they still incur in this practice. Theft of parental lines, this is becoming the big issue because it has a disrupting effect on the market. Usually seeds produced in China, in India, Thailand, then maybe imported into Jordan for conditioning, into Spain as well, and then sold into different countries. The sale of counterfeit seed packages is also a widespread problem, but this is mostly trademark infringement, which is, I have to say, much easier to prosecute. And we found this problem affecting many crops and in many countries. Usually, it's very useful to communicate with a right holder because they know exactly how to identify seed packaging. Fraud in rootstock, we found this issue in Turkey and Morocco. Basically, the plant raiser tells the customer they're using a rootstock X, when in reality it's Y, something else. Again, remember, PBR is often linked to a cluster of illegalities. If you encounter PBR infringement, you're probably going to find unfair competition, commercial fraud, tax evasion, phytosanitary offense, labor exploitation. So don't just focus on PBR. Look at the big picture. Because looking at the big picture, you're going to be able to rely on different authorities to help you: phytosanitary, seed inspection, anti-fraud, tax authorities, and the police as well. It is impossible for us in our work to prove infringement without help from authorities to enter premises. Most of the infringements are taking place in private premises, and we cannot really go in there. So we need the support of bodies within the Ministry of Agriculture to go and do inspections. Very quickly, I want to show you, we have implemented a case management tool that enables us to have global statistics about infringements worldwide. And we can show, for example, where we have the main hotspots based on the number of infringement cases we have received in those countries. What we want to do is, in the future, be able to tell our members exactly where we're having issues, not just by country, but also by location level within a country. For example, Lazio, which is a region in Italy. We want to know exactly which crops are most affected, and also be able to tell, for example, of all the reports we have received, how many are investigations in ongoing, how many are training activities, how many criminal and administrative cases. It's about having an overview, understanding exactly what's going to happen, and draw conclusions, and advising our members, you should go in this direction or in a different direction. Okay, what lessons have we learned so far? PVP protection provides the strongest legal ground to fight illegal reproduction. But of course, PVP protection is not enough. Enforcement is a different world. And it's not enough to have your variety protected. Countries that implement variety protection systems, they should also have reliable enforcement tools to enforce those rights. The basics when fighting piracy: mass balance analysis. This is key for inspection officers. They have to look at the invoices and check the number of seeds bought and the number of plants delivered. This is how you can actually identify inconsistencies. The time to act is very short because we're dealing with living materials. So the growing cycles are short, so you have to take action very quickly. And also the use of DNA technology to identify varieties. This is very, very, very key, especially when persuading authorities to go and take action. DNA needs to be accepted. DNA is accepted nowadays in homicide cases, and nobody questions this technology. So why should we question when applied to the vegetable seed sector? Yes, it helps if PVP is considered a criminal act, and it's important to assign a specialized national agency for enforcement of PVP rights. Testing laboratories, legislation should indicate the lab to be used by the courts for official testing. And yes, one specialized PVP court is better than 10 non-specialized ones. Without effective enforcement of PVR, there would be less incentive for breeders to develop new varieties. Without new varieties that can withstand the impacts of climate change, food security will increase. Together we can change that. Everyone has a role to play in enforcing the law. So thank you very much. And if you have any questions, you can contact me. That's my email and my phone number. For any questions, I'm very happy to answer those. Thank you very much.
Thank you so
I'll be
much.
happy to join you in person next time. Thanks again.
It'll be wonderful to have you, sir. Thank you so much. Ladies and gentlemen, it's our privilege to welcome Mr. Kwangong Lee from the Korea Seed and Variety Service, South Korea, as he shares his expertise on ground enforcement for encountering infringement and its field level experience. Mr. Lee will be joining us online. The stage is all yours, sir. Hello, Mr. Lee. Can you hear us? Okay.
Oh, I'm sorry. Are you here now?
Yes, sir.
Are you
Yes.
here?
Yes, sir.
Okay, thank you. I'm sorry. I'm very happy to be here with you. I was invited last week from Mr. Raghavan at Thailand. So this slide is basically from the PPT last week, but I a little modified for you. Now I start my PPT. I have two topics today. First, about talking about the PVP in Korea. Our organization is Korea Seed Variety Service right now. Was established in 1974 for the national seed production and distribution for the farmers. It is still working for that, and also we are doing seed industry management and development or seed market control management. We are started PVP system from 1998 from the Seed Industry Act. And we enjoyed the UPOV 2002 as a 50th member state. And the PVP law was separated from the Seed Industry Act in 2013. So here's the summary. We follow basically 1991 UPOV Act. We protect right now all plants species, and the duration of protection is maximum 20 years, but it is 25 years for fruits and forestry trees. We have provisional protection from the date of public announcement. And breeders' right is not limited for farm-safe seeds of protected variety right now. Here's our procedure for PVP. The applicant applies for the PVP, if it is accepted, we are public announcement occurs by PVP gadget. At this time, it has a provisional protection. By the examination of the US and novelty and the name, if it is accepted by examiner, then breeder's right is granted. If it is refused, the applicant can ask to PVP tribunal in our ministry, and if it also refused, it can go to patent and Supreme Court. Here's our documents then required for the PVP application, the basic application form and the breeding procedure, history of breeding, and variety description, and characteristics of new variety, and comparing variety according to the test guideline of a plant. And some photos is showing a difference between new variety and comparing variety. And also seed materials. And others are authority certificates. This is for the agents or foreign applicants have to have applied by the agents in domestic agents. So in that case, the breeder and applicant is different. The applicant have to submit the authority certificates. And in case of foreign application, parental quarantine certificate also needed. Here's the fee for all steps. DS examination is 500,000 won. It's about 360 US dollar, and the grant fee is different by years. We have three authorities in Korea. KSVS is started at the beginning. So basically agricultural crops and some other plants. And National Forest Seed Variety Service started from 2008, and it's all for the trees, in forestry trees, and wild native plants, and some agricultural crops. Basically, they grow in the mountain or hill, such area. And Aquatic Plant Variety Center is started from 2012. Yeah, this center is for algae and aquatic plants. Here's the application numbers and granted numbers. In total, from the last year, our total application is 14,150, and total grants 10,386. Here's some shows the applicants and crops. Here you just in summary total. If you see total, public organizations, national institutes or national organizations is about 42% of applications, and domestic individuals is about 18%, and the domestic company is about 20%. So the foreign application is also about 20%. And the foreign application is made, the most is from the Netherlands, and the next is Japan, Germany, USA, etc. I found that there's 3 varieties in ornamentals from India. From the statistics of UFO, there's top 10 countries, and Korea is number 9 here. So Korea is a very small country, but the application is quite high. Now let's talk about PVP, plant breeders' right. And the infringement is actually, the definition is that exploiting the protected plant variety without authorization of a right holder. And using the name of a protected plant variety is also infringement. So in case of infringement, it is less than 7 years of imprisonment or 100 million won of fine. The exploitation means that actually all of this is related in boundary of the breeder's right. So this basically these 7 acts, and also in case of harvest material or certain products, if it is the propagating material is unauthorized used, and also EDV and some varieties that not clearly distinguishable or requires repeated use of the protected variety. There's also exceptions, of course, for the private use or experimental or breeding purpose, or by laws restricting the breeder's right. So in case of infringement, there's 2 ways in Korea to protect breeders' right. That is non-judicial settlement mediated by Seed Commission. It is located in our ministry. And judicial settlement, it is by lawsuit. Comparing to judicial settlement, non-judicial settlement is cost very low and faster than a lawsuit, but it is non-compulsory. If the contract between the fighters not goes well, the accused person can go to a lawsuit. In judicial settlement, there's 2 is a civil litigation and criminal litigation. In civil litigation, is 3 kinds. In criminal litigation, there's 4 kinds. The breeder's right is basically in the territory of a country, affects in the territory of a country. So PBR have to apply it to each country. In other case, EC is EU is a little different example, but basically, TOP has to be applied by country. So if a breeder has a new variety, it has to apply home country and foreign country POC. In this case, if a breeder get a PVP from home country and foreign country B, in this case, if the parent goes to these 3 country, basically that this home country and country B should be illegal, but country C is legal because country C has not PVP for this new variety. For example, there's a green grape, Shy Muscat. The variety name is Shy Muscat. This variety bred by Naro in Japan in 1988. And it has Japan's PVP in 2006, but did not apply the foreign PVP within 6 years. So they found after 6 years later that the variety flows out to China and Korea, and the China and Korea exported the green grape to East Asia countries. sorry. Here they tried to make a social problem, but they have no other method to protect this because they did not have the PVP in other countries. In Korea, our organization has a special police office activity. We have one headquarters and 5 branches for the PVP. In each office has 2 or 3 police officers. So if the breeder or the right holder thinks that his variety is infringed, then he have to ask the police or to our special police officer directly about the infringement. So in that case, if the right holder asked us in our organization to survey the infringement, we survey about the infringement by consulting with the local prosecutor. So after investigation, we hand over all the data to a local prosecutor. So the statistics here shows that every year 1 to 3 these days occurs in our organization. In national status, there's about 30 to 40 cases, I think, every year. This is the case of infringement in kiwi fruit. I surveyed this case. This is a farmer and some kind of producing organization like that is a president of the region producing farmer, and he illegally propagated the protected variety, and the right holder found that the kiwi fruit in the market is not from his organization. So he accused us that it is infringing. So we investigated this man and found he accepted that it is an illegal propagation. So for he accepted the right holders condition, and he cut all his kiwi fruit trees and also buried all the kiwi fruits. I was stand at the spot. And another thing we do for to protect farmers and breeders is that we periodically investigate seed market, especially for the vegetables and fruit trees. We also have special police office for this dispute of seed or seedlings. The seed dispute of seed or seedling is basically between farmers and sellers or seed companies. So it has to be applies to a mediation committee. is in the ministry also. Yes. Then, if it is needed, seeds or seedlings of disputing is collected and tested, usually a DNA test or growing test. Of course, it's also if oh, I'm sorry. This is another. This is that if there's a dispute between farmers and the sellers for the seed problems such as germination or different varieties or qualities, which has a problem, the disputing person can apply for the mediation, and pseudo seedlings can be collected and tested. And if it does not end in agreement, the disputing person goes to a lawsuit. I am EC member of APSA, and the president is Dr. Manish Patel, India. India is the most member countries of APSA. So I really thank for the support of India companies to APSA. Thank you very much.
Thank you so much, sir. Thank you all for your engagement this far. Ladies and gentlemen, we'll break for lunch, but before that, let's join here for a group picture, please. Mhm. You may please gather here in front of the stage, and we'll quickly click a group photo and then proceed for the lunch. We'll begin with the next session at 2:45 p.m. sharp. So I request you to kindly come back by 2:45. After to our guests joining online, we'll have a group photo now here, and we'll break for lunch. We'll be back for the sessions at 2:45 p.m. So we'll hope to catch up with you at 2:45 p.m., please. Just remember, if you can see the camera can see you. Thank you, everyone. So we'll be back at 2:45 p.m. sharp. Hoping to see all of you. Thank you. 2:45, sir. We started. The lunch is on the ground floor. Pai, requesting all of you to please settle down. We request you to please settle down. We'll resume with session one shortly. Requesting you to please settle down. Welcome back, everyone. We hope you enjoyed your lunch and are ready for an engaging afternoon session. We'll resume with our session one overview of global, regional, and national policy landscape for IPR in seats. It's our privilege and with great pleasure, we welcome Ms. Samsravish Rain, Director of International Agro Arbitration Center and esteemed advocate at the Supreme Court of India. We eagerly anticipate your insights on ADR, alternate dispute resolution, its overview, and its relevance in the seed sector. The floor is all yours, ma'am.
Thank you. Ladies and gentlemen, it is with great pleasure and honor that I stand before you today as Executive Director of International Agro Arbitration Center. Our presence here signifies a crucial intersection of two pivotal pillars in the agricultural landscape, agriculture and the seed industry. Today, I aim to delve into the significance of alternate dispute resolution, ADR, the role of the International Agro Arbitration Center, IAAC, and the importance of intellectual property rights, IPR, within the agriculture sector, particularly focusing on the Federation of Seed Industry of India. Firstly, let us address the concept of alternative dispute resolution. In an industry as dynamic and multifaceted as agriculture, disputes are bound to rise. However, the traditional litigation process can be cumbersome, time consuming, and financially draining for all parties involved. This is where ADR steps in as a beacon of efficiency, offering alternative avenues such as mediation and arbitration to resolve disputes swiftly and amicably. By embracing ADR, the seed industry can foster a culture of collaboration, innovation, and sustainable growth. This brings us to the core mission of the International Agro Arbitration Center. At IAAC, we are committed to providing specialized arbitration services tailored to the unique needs of the agriculture sector. Our team of expert arbitrators and mediators possesses a deep understanding of agro related issues, ensuring fair and equitable resolutions that uphold the principles of justice and integrity. By leveraging our expertise and resources, IAAC serves as a trusted partner for stakeholders across the agricultural value chain, including seed producers, distributors, and farmers associations. Now let us turn our attention to intellectual property rights. Within the agro sector, in an era defined by rapid technological advancements and genetic innovations, safeguarding intellectual property is paramount to driving process and programming innovations. Seeds are the lifeblood of agriculture, and IPR plays a pivotal role in protecting the investments and innovations of seed companies. By securing patents and plant breeders' rights, companies can initiate research and development efforts. So, supporting the creation of high-yielding disease-resistant crop varieties that address the evolving needs of farmers and consumers alike. We explore the vital nexus between ADR and IPR in the agriculture sector and the vital role of international laws and treaties. As we navigate this terrain, let us draw upon arbitral awards passed in IPR disputes within the agro sector and reflect on the global landscape of ADR promotion by governments. In recent years, arbitral awards in IPR disputes have underscored the significance of ADR mechanisms in resolving complex intellectual property conflicts within the agriculture domain. These awards serve as compelling precedents highlighting the efficiency and legitimacy of arbitration in safeguarding the rights of seed producers, breeders, and innovators. By adjudicating disputes with impartiality and expertise, arbitral tribunals contribute to the development of a robust legal framework that fosters innovation and investment in agriculture research and development. Moreover, the landscape of international laws and treaties provides a crucial backdrop for understanding the evolving dynamics in IPR protection and dispute resolution in the agro sector. Okay. Moreover, the landscape of international laws and treaties Moreover, the landscape of international laws and treaties provides a crucial backdrop for understanding the evolving dynamics of IPR protection and dispute resolution in the agro sector. Treaties such as the agreements on trade related aspects of IPR and the International Convention for the Protection of New Varieties of Plants, UPOV Convention, established harmonized standards for IPR protection. Facilitating cross-border cooperation and enforcement. Arbitration, with its flexibility and adaptability, serves as a linchpin in the effective implementation of these international agreements, providing a forum for resolving disputes that transcend national boundaries. Furthermore, governments around the world are increasingly recognizing the benefits of ADR in promoting economic development, enhancing access to justice, and reducing the burden on overloaded judicial systems. Through legislative reforms, policy initiatives, and institutional supports, governments are actively participating the use of arbitration and other ADR mechanisms to resolve disputes in various sectors, including agriculture. By fostering a conducive environment for ADR, governments empower stakeholders to resolve disputes efficiently, thereby fostering trust, stability, and investment in the agriculture sector. Despite disputes in the agriculture sector can arise from various sources and can be diverse in nature. Intellectual property rights disputes, contractual disputes, land and property disputes, environmental disputes, labor disputes, competition and antitrust disputes, product liability disputes, insurance and risk management, government regulations and policy, technological and data disputes, and many such other disputes. In India, initiatives such as the promotion of institutional arbitration through the Arbitration and Conciliation Amendment Act 2019 or promote mediation through the Mediation Act 2023 and the establishment of specialized forums demonstrates the government's commitment to promoting ADR as a preferred method for resolving commercial disputes, including those in the agriculture sector. By aligning dispute by sorry by aligning domestic legal frameworks and international best practices and fostering a culture of arbitration, India is poised to emerge as a hub for agro related disputes arbitration, serving the needs of stakeholders both domestically and globally. The Federation of Seed Industry of India stands as the forefront of championing the interest of seed companies and promoting a thriving seed industry ecosystem. As a collective voice for the sector, FSII plays a pivotal role in shaping policy, fostering innovation, and ensuring the sustainability of India's agriculture sector. By collaborating with organizations like IAAC and embracing principles of ADR and IPR, FSII can further strengthen its position as a catalyst for positive change within the seed industry. In the end, I would only like to say that the challenges facing the agriculture sector are manifold, but so too are the opportunities for growth and innovation. By embracing ADR, leveraging the expertise of organizations like IAAC, and safeguarding IPR, we can pave the way for a brighter, more sustainable future for the seed industry and agriculture as a whole. Together, let us work hand in hand to cultivate a thriving ecosystem where innovation flourishes, disputes are resolved expeditiously, and the fruits of our labor benefit farmers, consumers, and society at large. And as we navigate the complexities of IPR protection and dispute resolution in the agro sector, let us draw inspiration from our arbitral awards, international laws, and governmental initiatives that underscore the importance of ADR in promoting innovation, investment, and sustainable development. By embracing ADR mechanism, harnessing the power of international legal frameworks, and collaborating with governments to promote ADR, we can chart a course towards a future where disputes are resolved swiftly and equitably, and the rights of stakeholders are upheld and with integrity and fairness. Thank you so much. Oh, yes, please. Are you expected to have a case solved by ADR in the agriculture sector? In the agro sector, no, not as of for now, since International Agro Arbitration Center was established last year in October 2023. So it's just a few months old in the market. Otherwise, if you are asking that whether we have been dealing arbitration matters, yes, but specifically to the agro sector, so this is one of a kind. You could say that we are still in the process of collaborating with the embassies, with the chambers, with the centers. So that is where in the process. So having such kind of matters, you really need that everyone knows about the center, and that's how the matters would be coming in.
It would to explain to the audience.
Yeah.
Your advisory board or who is in interest.
May I just have the PPT back?
Presentation thoda could I pause?
It's based in Delhi. Yes, it's based in Delhi, and I'm so sorry. I'm very bad with this.
The most important benefit that the audience would like to
Yeah.
know about is whether it can replace the current judicial delays and other things.
Yeah,
And
if everyone would like to know that this is very interesting part that in arbitration, well, how the judicial system works is that if you have a dispute, you go to a court, then you file a matter in a lower court or in a tribunal. Then the appeal goes. If you're not happy with the order, then you go in and appeal to the high court and then to the Supreme Court. So it takes years over there. So a trial court only takes around 10 to 12 years, then the high court another few years, and so on. So whereas in arbitration, there under the act, within 12 months, you need to have a judgment in your hand. That is called a award. So you will have a order in your hand, whether it's in your favor or not. It actually depends on the case, but you will have an order within 12 months in your hands. If you're not happy with that order, you can appeal in the high court and then in the Supreme Court. So the 10 years gap is shrunk to 1 year, and then you go to the high court and the Supreme Court for the appeal. So that is the best part about our arbitration. And since now we also have I mean, the mediation was always there, but now we also have a mediation act, wherein the government is also saying that the mediation plays such an important role, wherein um, both the parties come sit together with a neutral person. Both the parties would get something of out of the matter, wherein both the parties would be benefiting. I mean, if you agree to a certain point, for instance, I have a claim of around 1 cr, and the other person is saying that no, the claim is only of 50 lakh. So there in a mediation, both the parties win, wherein the first party would be saying that no, I'm not happy with this fight, and I don't want to go to court. So there the mediator would try to convince both of them that both of you could settle on a slightly reasonable amount. So someone might agree for 75 lakh, and the other one might agree that all right, I am willing to increase the amount from 50 lakh to 75 lakh. So that was a mediation plays a very good role in all the disputes. So arbitration and mediation is something that even the governments have also started promoting it. And post 2020, I mean post lockdown, since entire world, all the matters were completely shut. Only the criminal matters that would taken care of, wherein the person is behind the bars, and all the civil matters were completely shut. I mean, there was no work that was going on, and only arbitration was the only sector in the civil zone wherein arbitration was being done online and the matters were being dealt. So this way, most of the countries and the companies have started understanding the importance of arbitration, that this can be done online also. This will never be shut as a court got shut during the lockdown. So I think that ADR is the next litigation, you could say, in next coming years, 5 years at the max. You would be seeing a big boom in arbitration and mediation. So it's just a matter of awareness that everyone knows about it, and I'm sure everyone would be happy to come to arbitration center instead of going to a court. Well, yeah, this is our advisory board. So, former Chief Justice of India, he is the chairman of the advisory board, Justice P. Satasivam, and we have other dignitaries also. A former Supreme Court judges are there, Justice Gyan Mishra, Justice A.R. Dave, Justice Anjana Desai, and then we have ministers, we have senior advocates, and few of CEOs of different companies from the agro sector. Yes, yes. We do have rules. IAAC has its own rules. So the center would be working according to those rules, and it's of course it's available on the website. Everyone can look at it.
Hello. Hello, am I audible? Am I audible?
Yes.
Excuse me, ma'am, I have two questions. My name is Akash Awana. I'm a practicing advocate.
I can't
I'm a
hear you.
practicing advocate. My name is Akash Awana, and I'm a LLM student from National Law University, Delhi. I have two questions. First, if there already exists an institutional framework of India International Arbitration Center, which deals with the same commercial disputes, so why do we need required to have these in India Agro Arbitration Center? Second question is, if there are criminal offenses, which is a right in rem, a concept of right in rem, right in personam, you are familiar with. So, since there are criminal offenses exist in the legislation regarding this patent laws, so how could it come into arbitration? Because it's generally the arbitration is about the party autonomy, the consent of the party, the dispute between two individuals or parties having a private contract. But the law says that it has criminal penalties, which says that it's a right in rem. So the dispute of these, I'm unable to
All right.
understand.
So for the first one, wherein you said that we have different arbitration centers in India. Yes, we do have, but we don't have a specific dedicated one which deals only with the agro sector. We have the commercial arbitration centers, we have a generic arbitration center, but the agro specific, wherein you will have experts from the agro sector, a technical expert who knows about the seeds, the GMOs and all. So for that, we all actually needed a space wherein you have all kind of experts in the agro sector, so that you don't have to look here and there. You have everyone under one umbrella. So we have mediators, we have arbitrators, we have legal experts, lawyers like you who deal with the agro sector, and technical experts. Yes. Sorry, I'm not able to get that. Sorry.
For arbitration when out of the court, when you have to justify for legal rights.
See, this arbitration setup will have experts from agriculture industry so that they can understand the nuances of it and then resolve it quickly. That is the purpose.
And for the second question, so what happens is, unless and until there is a body injury, for instance, if you have murdered someone or something, those matters cannot come into a arbitration center. All right, but then if uh, you have intellectual property rights, wherein you have taken someone's right and then you have been using it, so of course you have that criminal code that is available. But I don't want to send you behind the bars, but I want that you have used my technology, so I want that I should be compensated for that. That is where it comes in. So criminal matters would be wherein we all could make out that these matters cannot be solved by a neutral person. Here you actually need a judgment. There is something, a major fraud that has happened. So here I want that the court should send the person behind the bars, or the criminal realm. Whereas for the civil one, the arbitration is wherein both the parties want that the matters are get settled soon. We get our compensation. I would give a very small example to it, but it's not related to the agro sector. So there was a company, Indian company, who was selling a fake Levi's jeans in the market. So the Levi's brand got to know about it, that they have been using my name and they have been selling the jeans and all. So they bought the matter in the arbitration center. They were claiming for a certain amount, that you have done so much of loss to us, so you have to give us. But this local company, their material was actually very good. So what they made a compromise there, that all right, we are going to do this thing, that you will not pay us any amount, but you will not make this kind of thing again for any other company, and from today onwards you would be taking care of my entire India Levi's brand. Manufacture will be taken care by you. So this kind of matter happened, and this was amazing one. So mediation and arbitration is a place wherein both the parties win. So here the person was that I am a big brand and I am making such good things and my name is so huge, but this person who is a local person has good amazing cloth, and that is what actually matters. So that way they were able to settle their dispute, and instead of going to court, sending them behind the bars, getting a millions of dollars. Yeah. Yes. Yes, yes. In fact, if you will see why we are promoting more ADR, and thanks to the seed association here, that if you will see that the farmers, they have such a major problem that the government is giving them some kind of a compensation for their thing, and they are not able to communicate that this amount is less or more, and like that. So when you have a mediation center wherein a neutral person, so I don't know you, I don't know you, and I am just sitting there that I want to hear both the parties, that mediator would be a appropriate person to tell that government official that look, this is wrong, he has spent so much of amount and all. So the emotions can also be taken care of in a arbitration center. So that is how we come into the picture. And I'm sorry,
Sorry,
I'm
in the
taking
interest
a
of
lot of
time, we
time.
just have one question from
Yes,
Dr. Dadlani,
thank you.
please.
Yeah.
Encouraged by what was presented just now,
Yeah.
I wanted to share two instances. One was I was talking to the earlier managing director of AIB. Ignacio is the present one, the earlier one. And what he mentioned was very, very important. What he said was, I asked him, do you have disputes? Because Venkat talked about protection of infringements. He said that there are several infringements and there are disputes. But the companies, they do realize that their prestige is so much involved that they prefer to sit across the table and discuss. Now, that is one way, that's one way of discussing, as was mentioned in the morning, sitting across the table and working out things, because they said that they don't want to lose out on their credibility as a company. The second thing which reminds me was when I was working with NSAI, I was once speaking to the chairman of PPVFRA, the then chairman. And what he mentioned was in one of the discussions, he showed me a list. He said that there are 29 infringement disputes pending as of now, out of which 23 or 24 are between two companies. So he said, what we are going to do is that invite those two companies to sit across the table with us and work it out rather than fighting the cases. Because what was mentioned in the morning, the cases linger on. You spend so much of money. Maybe the multinational companies, they have their own budget for these things. But most of the Indian companies being small, they do not have a budget for these things. So I think that we should be looking for more of such alternate mechanisms rather than really working out. I'm sorry
True.
for the lawyer community that
No. But then let me tell you, arbitrator and a mediator is also a lawyer. So
Lawyer.
for the
So,
lawyers, it won't be a problem.
yeah, true, true,
Ve-
true, true.
what I meant was वो तारीख पे तारीख लेने के वाला जो सिस्टम है ना
वो खत्म होना चाहिए. It's been ages now. इसमें मैं एक छोटा example दूंगी, wherein if all of you actually remember in Lebanon we had a bomb blast there, wherein mercury was kept near the port for 10 years or something, and that blast happened. That was the case wherein the matter should have come to a arbitration center instead of going to the court. So mercury again, so plants, if there is a kind of dispute wherein you have your agro plants and all, you can't sit and sit over it and then fight for it for next 10 years. So आपका वो crop ही चला जाएगा, जो technology है, everything will actually just go away.
True.
That's why arbitration comes into the picture. Thank you, sir, for
Thank you.
all
Thank
the
you.
insights.
And thanks, Samshravesh.
Thank you, everyone.
Yeah. So let's move on to the next session, that is a panel discussion. So we invite.
As Sir rightly said, our panel discussion is on IPR challenges for the Indian seed industry. I would like to request our session 2 panelists to kindly grace their presence on the dais. Dr. Deepak Prem, Chair, FSII Regulatory Committee and Manager Regulatory Advocacy and Scientific Affairs, Bayer Cropsize India Limited. Dr. Anushri Gupta, IPR Attorney. Mr. Surya Rao Rangoli, Lead Seed and Traits Regulatory, Syngenta India. Dr. Nitin Joshi, Seed Regulatory Leader, South Asia Corteva AgriScience. Dr. Dipal Rao Chaudhary, Joint Registrar, PPV FRA, Government of India. Mr. D.S. Rajaganesh, Legal Advisor, Protection of Plant Varieties and Farmers' Rights Authority, PPV FRA, Government of India. Okay. No. Qualification. Okay. No, whether- Deepak. It's a privilege to have Dr. Anushri Gupta, an esteemed IPR attorney, joining us today. May I kindly ask Dr. Deepak Prem to extend a warm welcome to Dr. Gupta with a small token of appreciation. Warm welcome. In the meantime, to हाँ खाया आप सबने खाया सर खाना अच्छा लगा आपको हाँ बोलिए जोर से नहीं लगा ठीक है सर वही जगाना चाह रहा हूँ मैं आप लोग अच्छा लगा खाना वेरी नाइस लाउड यस खाना अच्छा लगा वेरी नाइस अब थोड़ा जगने शुरू है ना लोग वेरी गुड सर आपने लॉयर्स के लिए इतना कुछ बोला है सो आई एम श्योर यू आर नॉट गोइंग टू स्लीप नाउ वी आर गोइंग टू मोर डिस्कशन अब सोने नहीं देंगे सर टाइम टू यू विल हैव लॉट ऑफ प्रॉपर जाग रहे हैं ना डॉक्टर निशी वार्म वेलकम थैंक यू सो मच फोटो में ऐसे लगेगा कि मेरे को दे रही है Thank you so much, sir. Thank you, ma'am. We are delighted to have with us Mr. D.S. Rajganesh, legal advisor from the Protection of Plant Varieties and Farmers' Rights Authority, PPVFRA, Government of India, joining us today. Could I kindly ask Dr. Nitin Joshi to extend a warm welcome to Dr. Rajganesh? Okay. Okay. Thank you so much, sir. We are delighted to have Dr. Deepal Rao Chaudhary joining us today. Can I please ask Mr. Surya to extend a warm welcome? Thank you so much, sir.
Roy. R-O-Y.
Okay, Roy. Thank you.
And Surya's name was also pronounced wrong because that his name is wrongly actually. It's not Rangoli, it's wrongly.
Wrongly. Okay. Okay.
So pronunciation.
My apologies. Okay. May I please hand over the mic to our session moderator, Dr. Deepak Prem? Thank you, sir.
Thank you. We've had a very busy, long day. I think all of you stay. All of you enjoyed the presentations. Who enjoyed the presentations? कोई हाथ उठाएगा या it was death by presentation? Only 1%. Did you guys, छोटे काले कोट वाले, did you guys enjoy? आप में से किसने पीवीपी का नाम आज तक नहीं सुना था? सीरियसली आप हाथ उठा सकते हो, कोई प्रॉब्लम नहीं है. वही 4-5 लोग हैं. संपत, we've been successful in educating at least these 5 people from this program. At least ये 4 लोग जागरूक हुए हैं पीवीपी को लेके. So this is good news for us. This session is a panel discussion. It will be very interactive. हम चाहते हैं कि आप खूब बढ़ चढ़ के हिस्सा लें, डिस्कशन करें और हमारे पास अगले 4 मिनट है क्योंकि 4 मिनट में खत्म हो जाएगी कॉन्फ्रेंस. So we are seriously out of time, but I think we will have permission to go on for maybe an hour or so. This is going to be a useful session for us because from this session what we intend to do is that we want to frame some answers to some frequently asked questions. These answers we will give as proceedings of this deliberation to the PPVFRA and request them, if they like these our answers and our questions, they can put them on their website in the FAQ section. तो आप लोगों के लिए होमवर्क रहेगा उसमें कि आप लोगों को नोट्स बनाने हैं और खुद से भी उसमें डालना होगा नोट्स में कि आप क्या समझते हैं, जवाब क्या होने चाहिए. वी विल हैव 4 questions only. It will be a very structured discussion. 4 questions. Of course, before the 4 questions, we will have Dr. Anushri. I know her as Anushri Gupta. Now she's Anushri Varshne. अच्छा, she was Varshne. She's now Gupta. Sorry, उल्टा हो गया. बचपन से. So at least 3 or 4 of us here we've grown old together. I have grown old with them. They are still young. So you can read about us. All what we are and what we do is written on this sheet. So we don't need introductions. We can straight away get on with it. So it's over to you, Dr. Anushri.
Presentation. So good evening, everyone, especially the young lawyers who are here and my all seniors, and also the Plant Variety Authority and the scientists available here. And thank you, FSII, who has given an opportunity here to speak about a very important aspect, that is what rights, what we get in the Plant Variety Act and how we implement it, and what are the remedies if somebody infringes or somebody violates our rights. So that's the topic what I'm going to speak on, and I hope that the later discussions will help in this. So first of all, when I talk about the remedies, one should know what are our rights when the plant variety registration is given to you, to a breeder or an assignee or a successor, what rights the person gets. So right, if this is absolutely what has been defined in the Plant Variety Protection Act, it is rights are conferred subject to the provisions of this act. A certificate for a variety issued under this act shall confer an exclusive right. Now, it's an exclusive right to the breeder, right on the breeder, on his or his successor, his agent or licensee to produce, sell, market, distribute, import, or export the variety. So these are the rights which have been given to a registered breeder, provided that in the case of extant variety, unless the breeder or his successor establishes his right, the central government has the right, or in case where such extent variety is notified for a state or for an area thereof, then under Section 5 of the CET Act 1966, the state government shall be deemed to be the owner. So until unless the in extent variety, until unless the breeder establishes that he is the owner, the central government or the state government will have the ownership. Now, when these rights get violated, now what are the remedies? Now, what is remedy? I'm sure all the legal people sitting here understand what is remedy. When a court is handling a case of any infringement or violation, so the IP owner, what happens is it can order the wrongdoer to stop, that is, provide an injunction and let the person who filed the lawsuit, the plaintiff, choose to receive money either in form of damages or a part of the wrongdoer's profits. So whatever the wrongdoer or the infringer or the violator is having the profits, taking the share out of it, or taking the damages. So that's a choice of the plaintiff. Or if that is taking time, immediately provide injunction. So that's what code gives the remedies. Now, remedies in plant variety protection in India is under the act is at 2 stages. One is before the grant or before the registration of the variety, and the other after the grant of the registration of a variety. So interestingly, it is the only IP law, Plant Variety Protection Act, which provides the protection before your grant, before your registration. Now, what is this provisional protection? Dr. Mahapatra, the chairperson of Plant Variety Authority, already emphasized and said that we are made the committee, and also they are trying to make the guidelines for this provisional protection, which is very important because it really takes some time, maybe 5 or 6 years, to get your registration done under this act. So meanwhile, if anybody violates or infringes the breeder's rights, so interests, not rights, the rights only confer when the registration is granted. So how one should protect that? So Plant Variety Authority plays a important role here. There is a provision in the Plant Variety Act, that is Section 24(5), which states that the registrar have the power to issue such directions to protect the interests of a breeder against any abusive act committed by a third party during the period between filing of an application for registration and decision taken by the authority on such application, that is by the grant of the registration of the variety. Now, what are the requirements when you are, if you have filed an application under PVP, what are the requirements to go to the authority for filing the provisional protection? An applicant must have filed an application for registration of a variety first. Then application for provisional protection is to be filed at the Plant Variety Authority. You don't have to go to any court or anything. It is at the authority that you go to file this application. An application for provisional protection filed by the applicant or breeder is generally considered when abusive act is committed. So when somebody has violated or is infringing your rights, then only you have to come with the application for provisional protection. And it is only for the interests of a breeder. Now here interests may be defined later, or the rights which you're going to confer after the registration. So those are the interests to be protected. Registrar will protect the interests of the applicant breeder by issuing some directions from the date of filing of application to the date of grant of the registration. Now, provisional protection is valid only in relation to acts which would require the breeder's authorization once the right is granted. So, therefore, if the right is not granted, provisional protection is not applicable. Suppose while examination, the Plant Variety Authority declares that your application cannot be registered. There have been issues and therefore it is rejected. So, provisional protection will not be provided for such kind of varieties. It is only once it is granted, then only provisional protection will come into picture. It will be given. Only directions will be given by the registrar that yes, maybe you can get once you get the right, you will have the due damages or whatever directions it has been decided to give to the breeder. In cases where it is possible to initiate legal proceedings before the grant of a breeder's right, the registrar may issue directions to protect the interests of a breeder and would only be enforceable once the right has been granted. Now, there have been case laws. Of course, there have been applications filing for provisional patent has been initiated at the Plant Variety Authority. There had been case one UPL versus Nijuvidu, which has been a very famous case, where for which UPL had filed the application for provisional protection, and of course, since it was not clear at that time, and now the guidelines have been in the process from the Plant Variety Protection Authority to make it. So it was earlier been rejected, and they went to the court UPL that we should get the provisional protection, and therefore now that case is reinstated, and they can now file an application for the provisional protection, which has been now active at the authority. Another application has been filed for watermelon, the variety Max X, by the applicant Newhams India Private Limited, which is pending at the authority. Yeah, sure. But this is public, sir. It's in the public domain. Sure, not an issue. It's there in the authority's website. Now, what is infringement? After this, once you get the grant or registration of the variety, what is then comes into picture is infringement. Now, what is infringement? If a person who is not a breeder of a registered variety or a registered agent or a licensee of the breeder sells, exports, imports, or produces such variety without the permission of a breeder or licensee or agent, the person infringes the right established under the Act. And the right is also infringed if an unauthorized person uses, sells, exports, imports, or produces any other variety giving such variety a denomination which is identical with or deceptively similar to the denomination of a variety registered under the Act, which may cause confusion in the mind of the general public, is also infringement. Suppose you are selling a packet with the denomination which is already under registration, which is registered by the plant variety, say AB, and similar, the other infringer, the third party, what he's doing is with the AB name, that denomination, he's selling the seed packet with that, and selling it in the wrong with the denominator. Those seeds are not of the breeder; it is of the infringer. So this is again is an infringing act. Now, suit for infringement. A suit for infringement can be instituted at a district court or a higher court, depending on the jurisdiction to try the suit. A court can grant relief in case of infringement, and the relief can be in form of injunction or damages or share of profits at the option of the plaintiff. Now, there have been case laws for the suit for infringement. PepsiCo case has been very, very famous, and it has been known to public, and it has been in the limelight and also been published in various newspapers and forums that they had filed an application at the Plant Variety Authority for the Lay's potato variety, and it was granted by the authority, and the Gujarat farmers were infringing their rights. And since they filed an infringement suit, simultaneously, the one of the farmers activists, Kavita, filed a revocation case at the authority. And that revocation case went on, and then the certificate was revoked. So PepsiCo went to the court, and then the single bench at the Delhi High Court, the IP bench rejected their plea, and then they again challenged that in the divisional bench. And in January 9, 2024, the divisional bench accepted their appeal, and the case was heard, and PepsiCo could get their reinstated their certificate again. There's another case happening at Kaveri Seeds versus Pioneer Seeds. This infringement case is active, which is for maize. And there are many other cases which are still not in public domain, but infringing has been going on in this area. So thank you. Just giving you a limelight what cases are being for violation is happening. The only thing is that how to deal with it. The courts are there, and also now we heard in the previous talk that arbitration center is also open. Probably it will be probably helpful in this area, so we look forward for that. Thank you.
Thank you very much, Dr. Anushri. I think one thing I can add to your presentation is that वो पिछला एग्जाम्पल जो लीवाइस का था ना कि you ask that infringer to make the same jeans but exclusively for Levi's only this time. I think this kind of arrangement is also done in the seed sector, and mostly this is how we resolve dispute on PVP, plant variety protection, because our intention is not to put somebody behind bars. And we are not living in the United States where you can have millions of dollars given in a suit. हमारे तो केस ही इतनी देर तक चलते रहते हैं कि लोग मर जाते हैं तब तक. तो मतलब मेन मकसद ये रहता है कि आप लीगली धंधा कीजिए, जो भी काम कर रहे हैं आप उसको लीगली कीजिए. एंड द पीवीपी लॉ, इवन प्रोविजनल प्रोटेक्शन दैट वी आर टॉकिंग अबाउट, these are meant more for encouraging licensing, ताकि people come, take licensing, and both of the parties earn instead of stealing. I'm reminded of one of the things that Dr. Mahapatra said in the morning, that awareness for IPR and respect for IPR needs to be inculcated from schools in our society, in our culture. आप लोगों ने 12th फेल देखी है? किसने नहीं देखी? सबने देखी है? उसमें एक बहुत अच्छा डायलॉग है लास्ट में. When he goes and gives that card, the hero goes and gives his wedding card to the big guy and says, सर मैंने आपकी बात मान ली, मैंने चीटिंग करना छोड़ दिया. जिस दिन हमारे देश में ये बात जज जाएगी ना कि चीटिंग नहीं करनी, ये भी चीटिंग ही है जो हम सुबह से बात कर रहे हैं, तो ये भी सॉल्व हो जाएगा. That is why when you hear Ignacio talk, you kind of you heard Ignacio talk, no, about arbitration, how they do it in the European Union and all. There's a certain amount of maturity when it comes to respecting intellectual right. हमारे यहाँ बौद्धिक संपदा को जैसे डॉक्टर महापात्र ने बताया था ना कि वो सर्वजन के लिए है सारी नॉलेज, हम उसी भ्रम में जी रहे हैं अभी भी. So I think we have to come out of it, and I think it's time for our 4 questions that we will discuss. The first question is visible on your screens. There is no ABC right answer in this. It's going to be a discussion, not really. All the answers will not come from us or from the panel. I don't need to read the question out. This question is what Dr. Yogesh Pai also talked about in the morning. If you are attentive enough, he talked about how IPR and other laws interact with each other, how patent and plant variety protection interacts within each other. So this is a case, or the question is, if there is a EDV registered with a GM trait, then what is the status of the patented man-made gene in this EDV? I've given an example here. The word apple is a pure coincidence. I couldn't get any other name in my mind. This has nothing to do with the Apple Industries जिनके फ़ोन वगैरह होते हैं. ये खाली यहाँ एग्जाम्पल की तरह पे नाम रखा गया है. तो एप्पल नाम की वैरायटी आपके पास पहले थी, आपने उसमें बीटी जीन जो मैन मेड पेटेंटेड जीन है इसे इंट्रोग्रेस किया और एप्पल बीटी के नाम से एक और वैरायटी बना ली. एप्पल नाम की वैरायटी आपने पहले न्यू वैरायटी के तौर पर प्रोटेक्ट करी थी और एप्पल बीटी को आपने ईडीवी या एसेंशियली डिराइव्ड वैरायटी के नाम से प्रोटेक्ट कर लिया, बिकॉज इसमें सिर्फ एक ही चेंज है, सिर्फ बीटी जीन ऐड हुआ है, बाकी सब पुराने एप्पल जैसा ही है. जैसा एप्पल के फ़ोन के साथ होता है ना, कुछ ही थोड़ा सा ही बदलता है वैसे, तो कुछ वैसा सही है. बट ईडीवी जो बना अब, तो व्हेन समबडी under researchers right, does anybody remember researchers right, black coats? You remember? For once you can use a variety, this is also called breeder's exemption in UPOV. So for once you can use a variety for research purpose. तो प्लांट ब्रीडिंग में ये बहुत सियानी चीज़ होती है. आप एक बार को क्रॉस बना के कोई डिजायरेबल जीन्स अपने बैकग्राउंड में ला सकते हैं, अपने प्लांट मटेरियल के बैकग्राउंड में, पर उसके बाद बहुत मेहनत लगती है. इस केस में मेहनत कम लगती है बिकॉज एक ही जीन है और उसका मार्कर भी है आपके पास. तो आप अगर ऐसे ईडीवी से इंट्रोग्रेस कर लेते अपनी लाइन के अंदर वो पेटेंटेड बीटी जीन को, तो क्या आपको पेटेंट वाले से अब कोई लेना देना नहीं है. यू डोंट हैव टू पे रॉयल्टी टू द पेटेंट गाय, यू ओनली कैन पे रॉयल्टी टू द ईडीवी होल्डर. So these are the two sets of questions, that who do you actually pay royalty to and whether the patent holds or it doesn't hold once the gene is inside the plant. I'd like to have some thoughts on this from anti-clockwise because this is the industry side. I am also part of industry. तो मेरा झुकाव इस तरफ ज़्यादा है. तो मैं इंडस्ट्री से शुरू करते हैं, फिर आप में से भी पूछेंगे कि if any of you have any thoughts, please give those as well. Surya, over to you. Why can't?
Thank you. Thank you, Deepak. I think this is a valid question for the today's the industry. Of course, this is a challenging question for last few years also in the industry. Whatever I'm expressing my views are from my personal as well as on behalf of my organization. It's nothing right or wrong because this forum, we want to come up with a solution which can be suited for everybody's alignment. So as you rightly mentioned, the PVP, plant variety protection, is supposed to be harmonized with other laws. It can be a patent, it can be a what is that? Trademarks, it can be a geographical indications. So whichever is related to this, rights related to the variety and then the associated denomination, this has to be harmonized. Second, the PVP law says, particularly for the denomination, if it is already trademark protected, then it cannot be given the denomination for the plant variety, the second option. So that is clear. But other laws like patented, if it is something is already patented, can that be used here without the prior permission from the the technology owner? So that was not clear, not for the denomination per se, because we are using BT also. The denomination, for example, Bolgard 1, if I take the permission to use it. So when I integrate my trade, so I'm using the BT term as well. It may not, whether I can use it or not, the terminology. And then the patented gene, which is already protected somewhere else, like a patents. So again, giving by PVP authority separate one more right. So is it another issue? How can this be harmonized between these two acts? So I think it has to be, in my personal view, it has to be given to the, if it is already protected elsewhere, that should not be covered in the variety can be protected because the trait is, for example, disease resistance or maybe the insect control. So the trait is there, but the trait is not expressible in the morphological characters. So that variety can be protected as EDV, but that has to be taken prior permission from the patented owner. Then it will be a justifiable thing, because nothing wrong. Because ultimately we all are discussing about the encouraging the investments in IP, the innovation, and then ultimately agree to share the benefits if somebody is investing. Again, why you want again re-innovate the same thing, which is already somebody invented. In general, my view, if something is already innovated, and then it is good to have a license instead of doing re-innovating same thing like re-engineering. So we don't encourage those things, but good to encourage the investments which are already made, and then it has to be dealt with the harmonization. Very clear thing. If something is protected, then it should not be again re-protected in some other acts. Those harmonizations, if at all, like morning also chairperson told, if you are thinking for any what is that amendment of the act, so these brainstorming session outcomes supposed to be incorporated into the amendment of the act. These are my personal views. Thank you.
Thank you, Surya. Nitin.
Yeah, thank you. So my friend Surya has covered a lot of things, so I won't talk again. And so my just because here are mostly the students, so like the variety, whatever is there in general in a layman's language. So the variety what we register under the Protection of Plant Varieties and Farmers' Right Act. So as a variety, if, although it is being derived by essentially what we call essentially derived variety, derived from the base variety, the registered variety. So it may be of my company also. The base variety may be of mine. And this is the new variety having some, let's say, insect tolerance, what has been mentioned. So it is my variety. I don't have to pay anything. But maybe there is another point is about the gene. So the gene is not protected under the PPVFR Act. It is under the Patent Act 1970. If that gene belongs to me, I don't have to pay money. I have to make money. So, but if that gene I have taken, let's say from many of you, then I have to, your patent is there, so I have to pay royalty to you. But another point is important here. In in this case, neither of the Patent Act nor PPFR Act will come in play. This is the agreement between you and me. We will decide how much I have to pay. This is a negotiation between two parties. The government regulatory authorities has nothing to do with this. Sometimes this also comes into picture that this will be decided by this authority or that authority, but it's a business case. So we will take a call and we will move ahead.
By you and me, you mean patent holder and you?
Yeah.
Okay. Great. They've covered most of my thoughts. Maybe I can pass it on to Dr. Deepal.
Thank you, Deepak. So I am audible. So Dipal Rai Chaudhary, I look for in a few crops like rice, maize, cotton. So most of these BT, what Dr. Deepak said, is in cotton. So let me explain to you what you understand by a plant variety protection. A plant variety protection under any statute of uh, any country in the world gives protection for two things. One is the denomination as the variety, right? So there is no trade protection as such under plant variety protection law in any country. But trade protection is being given through different other mechanisms. For example, in US, they have a plant patent, they have utility patent, and they have some other mechanism as well as plant variety protection law. So that means that in US, if you have a BT gene inserted into a variety, it can be protected under plant patent if it gives you a new feature in that plant patent. If it has an utility, it can be protected under utility patent, as well as that variety can also be protected under plant variety protection law. So as my friend Nitin has rightly said that a plant variety protection law as we have in India does protect only a variety. And if you have a insertion on a BT or whatever transgene, then there are licensing mechanisms available in India also, or it is between the trade provider or maybe the recipient that you discuss upon, come into a conclusion, whatever the agreement or payment or whatever you would like to pay for that trade may come into force. But as I said, we are open to it. As chairperson today has said that we would look for special trait in future. So I give you an example. Everybody knows about this genome edited crops, right? So we talk about CRISPR-Cas or different mechanisms for that. And globally, there are a lot of developments, including India. So in US, these genome edited plants have already started giving protection, and a few of them. Let me give you an example. There was a lettuce variety protected in under US PVPA somewhere in 2022, which has 5 genes where the polyphenol oxidase knocked off by nucleus and some other mechanisms. But these 2 genes were inserted through agrobacterium mediated transformation. So see, the unique part of that technology is that once you use agrobacterium mediated transformation to introduce those nuclease and other mechanism, that becomes a transgenic technology. But what they have also done in that once the gene edits like this 5 polyphenol oxidases which reduce the browning of lettuce and are more marketable and good for salads and all, once the edits are there, then by way of crossing and selfing, they just knocked off this agrobacterium mediated genes. So then it becomes a native one exactly. So then that variety goes as a normal variety in plant variety protection law. Because in US PVPA, if you want to register a transgenic material, remember US PVPA, the act is in 1970, enacted in 1970. Initially, they used to say a gene event has to be there. But very recently in 2018, they have changed that terminology. They said nucleotide, maybe a single or multiple nucleotide insertion into a genome. Probably they thought that CRISPR-Cas will come into play in near future. So why I'm telling is that in this particular variety, they have PVPA protection on this. But again, they are very clever. They also had a utility patent because there is a trait which gives you an utility, reduce browning of that. And then they have a plant patent on that particular variety also in 2019 that it gives a different stature. So they have a multiple protection. But in India, we only have plant variety protection. So the surmise is that as on date, we can only have a plant variety protection, which gives you a protection on variety only, but not on trait. But when you talk about special trait, this is a very recent discussion. Once Dr. Mahapatra has assumed his office, we had a committee under Professor Sapan Datta, Dr. Sapan Datta, who was earlier DDG Crop Science, and there were a lot of other people also from the industry perspective. Dr. Char, Bharat Char from Mahiko is a member. Probably that committee will look after what are the specialty trait that can be identified. It can be, disease resistance, biotic stress tolerance, or so on and so forth. There are a lot of things where the breeders are going for. Now, next challenge would be whether once we have those traits incorporated in plant varieties, whether we would be able to protect those traits or we will be able to protect only the varieties. That is still a challenge. But as on date, EDV as such, globally also, only plant varieties are protected, not the trait as such. And trait itself is regulated through the licensing, cross-licensing mechanism. That is what my, and of course for EDV, we have constituted a committee under Professor S.S. Banga, and we are looking after several aspects on this ETV. That is one of the aspect, and also the regulatory challenges for CRISPR-Cas, if those are coming, whether they would be treated under EDV clause or they will be treated under whatever the clause it is. That is for my response. Thank you.
Thank you, Dada.
He called me Dada. Spelled out because we know each other.
वो बताया था ना शुरू में, बचपन से जानते हैं, तो ये बचपन से दादा ही है. So it was such a excellent scientific conversation that half the black coats have gone. ज़्यादा science हो गई. But अच्छा.
Not meant for them as
Maybe for them it will be very science heavy. Raj Ganesh ji, over to you.
For this slides. Thank you, Dr. Deepak Prem, sir. Sir, the issue raised in this question is also involved in a case before Supreme Court where the division bench revoked this BT cotton patent, GM patent. And thereafter, again, when it went to Supreme Court restored the patent and remanded back the matter to the single judge. And before the learned single judge, all the issues are open for consideration. So that is the stage. And as far as Dr. Deepal has highlighted everything, and nothing is left for me. Only thing I like to say is for EDV now under the direction of our learned chairperson, sir, we are technically overhauling ourselves and introspecting very deeply. Now we have constituted a committee to under Dr. Deepal is also the member secretary of the committee. So what would constitute EDV? So we are going into the question, what would constitute EDV? What all would be the EDV? And parallelly, there is also another committee which we have constituted under the chairmanship of Dr. Sapan Datta, in which Dr. Bharat Char is also the seed industry representative. And in EDV committee, who is the seed industry representative, sir? Okay. Seed industry representative. कोई बात नहीं, sir. And so in every committee we are constituting, by all technical committees, we invariably have a seed industry representative. And so in this committees also it is there. So we are going to decide what would be the EDV and what would be the special trait for which which could be incorporated in the dust test guidelines. So all things are under examination. Only thing I will like to say is that we'll take into consideration the valuable views of the seed industry, and to facilitate them, the ease of doing business will be our motto, which was even highlighted during in the morning session also. So with those motto and with these things only, we will be framing our guidelines and procedures in a very democratic way after hearing everybody, including the seed industry. See, in every aspect, seed industry is associated with us. Even in our authority, seed industry representative is there, and he's yet to be appointed shortly by the honorable minister. So with this assurance, I just had so.
Thank you, Raj Ganesh ji. Thanks a lot. I think we will talk more about EDVs in subsequent questions. There are more questions towards that. Dr. Anushri, if you can keep your answer very short. No, the other mic.
Yeah. So, since the question is about the two patent, the Patent Act and the Plant Variety Act, so the two acts are totally different. Now, when the Plant Variety Act was made, it's a sui generis, and why it was made, nobody asked the question. The question was that under Section 3J of the Patent Act, any plant or its parts, seeds, varieties are not patentable. So it is excluded. Therefore, the Plant Variety Protection Act came into picture. So there is no question at all that the EDV, which is here being made, is to be protected under the Patent Act or the Patent Act trait or the method of making the transgenic plant. The Monsanto case, which has been talked here, is they had protected in their claims in the Patent Act at the what they got in the patent is the method of making the transgenic and the nucleic acid sequence of the gene, which was protected in the patent. And in the EDV here, it's essentially derived variety having that trait. So the trait is not protected in the Plant Variety Act. So the two things are totally different, and one should not mix it up. They are two separate. And as far as royalty and other things to be carried out, it has to be dealt with that who is having the right. If the patent holder has the right for the trait and the method of growing it, so that has to be duly respected. And the EDB variety which has been made by the breeder should be equally respected. So the two have to have their due rights and due royalties are to be paid to them respectively. Thank you.
Yes, Dada, of course.
Sorry, regarding what Anushree was telling, why I said Anushree, we also know since very long. Whatever. On 7th February 2024, European Parliament has proposed a legislation. It is not yet passed. That they said that the NGTs, the new genomic technology crops, they will not be patented. So this is under the proposal stage as on date, which is entirely different from what European Patent Office, which is not a part of the European Union, which is a separate entity, whereas European Patent Office thinks that the NGT crops will be patentable and parts of that NGT crops, the gene sequences, everything will be patentable. So in Europe, there is a stalemate as on date. So we are not sure what the global progress. In US, they are patentable, but not in
I
Europe
think
as on date.
this is one of the subsequent questions also, Dada. How do we protect gene edited varieties, or specifically how do we protect the trait, because traits are not protected in any PVP regime. because अगर ट्रेड प्रोटेक्ट करने लग गए तो रिसर्चर्स राइट का कोई फायदा नहीं है ना, बिकॉज अगर ट्रेड ही प्रोटेक्ट हो गया तो रिसर्चर्स राइट का करेगा क्या. So I think it's there are three more questions. So does anyone from the audience want to comment on the first question? Please. We have to only keep the button pressed. We can let it close.
Hello, can you hear me? Yeah. Can you hear me now?
Yes.
Yeah, so for hybrids like BT cotton that incorporate a patent gene into an essentially derived variety, the status of EDV usually remains under the protection of the original patent holder, requiring the EDV developers to obtain authorization for its use. I had a question though, how are licensing agreements that are typically structured between the original patent holders and developers of new EDVs to ensure compliance with the patent laws? Like, how are they typically structured to ensure compliance with the patent laws?
I think that's a that's a smart question to ask because it's not in the syllabus for us, you know.
I would like to speak
Because
for that.
I think you see trade licensing agreements, um, they're similar to what can be variety licensing as well. So most of this is a two party agreement, जैसे house rent agreement होता है उसी तरीके का होता है वो. I mean it's not very different from a house rent agreement. The only difference is that you can use specific technology terms in these kind of agreements where, for example, if I have, I represent Bayer Crop Science. So if Bayer Crop Science has Bolgard and Bolgard 2 as BT cotton in India, so for our sub licensees, we will tell them that please don't mix our trait with any other genetic trait or gene modified trait or another transgenic. So उसमें breeder को ये ध्यान रखना होगा कि he doesn't mix up two technologies or two patents coming in one background. तो इस तरीके के कुछ exclusive clause, scientifically exclusive clause can be kept, but I think the agreements as such are pretty standard licensing agreements. They are not very different from other two-party agreements. So the only difference in the first question part is that what if the EDV guy starts doing an agreement saying कि अब तो trait plant में आ चुका है, तो अब वो plant का हो गया. That is the argument which confuses people. In fact, Raj Ganesh ji talked about the case where the patent was revoked. It was indeed revoked, but this was the kind of argument given. Once the trait is in the plant, it is now a plant trait. How many of us had COVID shield vaccine?
Only one?
हाँ, अभी पढ़ा सबको न्यूज में आया AstraZeneca said that it has side effects and all COVID shield people will be impacted, right? So now the vaccine is in us. It is a part of DNA. It has been put in us in some form. It will never become part of human DNA. It will never be called human DNA. If you analyze COVID antibodies in me, natural COVID antibodies and antibodies elicited by the vaccine will be different. And they can be differentiated by science. तो जो चीज़ कृत्रिम तरीके से बनाई गई है, आर्टिफिशियली बनाई गई है, वो अगर प्लांट में है भी तो भी वो आर्टिफिशियल प्रोटीन ही बना रही है. It is not becoming a part of the plant genome.
That's correct. So the trait cannot be mixed with the variety. It is put, but the trait remains as an patent has been granted on the nucleic acid sequence, which is the gene which is responsible for this trait. So that is different, and the variety what you made is the protection is given, as I said, the PVP and the patent cannot be mixed. They're two different acts.
I hope you got your answer.
Yeah.
So,
Sorry,
what's your name? Please tell your name also.
Aditya Sagar. I'm still in the first year of National Law University.
Thanks, Aditya. That's a very good question for a first year student. You guys are doing good work, it means, in the National Law University. I think let's go to question number 2 because that talks about infringement scenarios in India's problem faced. I would request, again, in the same sequence, one problem per person. So we can, at the end, have at least 6 problems and 7, 8 problems if you guys also pitch in. Okay, Surya, over to you.
Yeah, thank you, Deepak. Particularly the plant variety protection, the awareness among the enforcement authorities. When I say enforcement authorities, judiciary, police, and then the Department of Agriculture, who can collect the sample and take send for the laboratories. So it is a minimal. We can say that somewhere it's even zero. Even the lawyers, because that once the registration is granted, we have to go to the ground level where the at least a district, the mandal level, the court is the authority. So there the lawyers or judges, sorry to say it, but this is the ground reality. So they don't know about the PVP law, how to identify it, how to what is that exactly it is. So our personal experience, when we approached the lawyer itself, whom we approached, he doesn't know about this law. And then he doesn't know what is that variety, because when I say maize, the maize is the maize. It can be yours, it can be mine. For them is a maize. They don't understand the differentiation within the maize. So this was very big challenge when we initially they gone to the field. And third, the crop is in field.
Only one
Sorry. Yeah. No, this is the infringement only. So the crop is in field. So you know that in the farmers' involvement when it is in field, so taking action against in the field, which crop is standing, it is almost impossible. So the scenarios what I faced in educating the local lawyer, educating the local police, because police also don't know. And then find these, including taking them to the field and then explaining them what is it, how it is different from us, and all those things. It took a lot of time. After that, everything, the police, because they don't want to register case because they don't understand what is exactly this case. So finally, the guidance came from the higher ups. We followed up, and then the collector, the who is district collector, he knows about the IPR rights. So then he suggested us, because he helped us to call to the local SP and then given the guidance, then the people come and then helped us in filing a case. Later, you know that these are not, but first of all, it's a civil case, then we drag them into criminal case because the parental lines, they theft and all those things. So these are the ground realities. Even though the present scenario, you have, of course, I'm not commenting about the registration process and all those things. Even though we have a protection in hand, ground level enforcement is really hard. So that is the point just I want to highlight.
Thank you. Nitin.
Yeah. So I have to talk about another problem. So uh, the problem is that once we see, in the field that our sales team, they suspect that this another variety having the characters which is matching to our hybrid, let's say. ठीक है ना, जैसे आप लोगों ने ब्लैक कोट पहना ऑलमोस्ट सेम, बट हो सकता है ब्रांड लेवाइस का है, किसी का दूसरे का ब्रांड है, तो देयर मे बी सम डिफरेंस इन द स्टफ. So how to prove that? So like another part is we are like Corteva. I am from Corteva AgriScience. So we are multinational. So before touching any hybrid, so we have to take prior approval from National Biodiversity Authority. तो अभी हमारा खाली सस्पेक्ट है कि ये हमसे मैच करा, बट जब तक आप कुछ टेस्ट नहीं करोगे, डीएनए प्रोफाइलिंग नहीं करोगे, यू वोंट अंडरस्टैंड. तो अभी इशू क्या है कि वी हैव टू टेक प्रायर अप्रूवल फ्रॉम द एनबीए ऑफिस, which takes normally 6 to 9 months. और and they ask, from where you will get it. अब जो चोर है वो कोई आज यहाँ बेच रहा है, कल को उधर भी बेच सकता है. They can change the location, but एनबीए ask the exact location कि आज ये मीटिंग हो रही है सेकंड फ्लोर में, तो उनको यहाँ तक का पूरा चाहिए, बिकॉज दे से वी गिव इट बैक टू द सोसाइटी. So this is the major issue, which is a hindrance. So since today we have, I mean, take this opportunity, our authority team is here. So I would just a suggestion to them also that whenever there is a suspicion, I mean, we are suspecting, we are still not confirmed, we can go to them and we can request them to take those hybrids and varieties and do the DNA profiling in their government labs, and so that they are a neutral party. So if that is the case, we can go to the court, and other party won't say that the second party has done all the testing and collection. So this is a request to the authority as well.
Yeah. I think the alternate side of this, Nitin, can also be that we seek exemption from NBA for this kind of access. If we have a registered variety, मैंने रजिस्ट्री करवाई, रिसर्च करके वैरायटी बनाई, उसको 3-4 साल लगा के पीवीपी वालों के पास रजिस्टर करवाया, अब कोई चोरी कर रहा है तो मुझे पहले कोतवाल से परमिशन लेनी पड़ेगी कि मैं ले लूं, इसका सामान देख लूं, चोरी तो नहीं कर रहा. मतलब ये देखने के लिए भी मुझे परमिशन चाहिए. तो इस चीज का एग्जम्पशन, वी कैन आस्क एग्जम्पशन फ्रॉम एनबीए फॉर एटलीस्ट दिस काइंड ऑफ टेस्टिंग, so that this testing becomes easier. For otherwise, for there's a, just for the reference of the guys in black coat, there's a 3(2) section in Biodiversity Act which says that any company that doesn't is registered in India but has foreign holdings, etc., whichever is a foreign company, they do not have access rights in India. They have to seek permission to take access. तो अपना ही बनाया हुआ जर्म प्लाज्म आप यहाँ पे रजिस्टर करवाने के बाद, पीवीपी करवाने के बाद, उसको एक्सेस करने के लिए फिर आपको एनबीए का अप्रूवल चाहिए. तो आई थिंक आई हैड द सेम क्वेश्चन, सेम पॉइंट लाइक यू, नितिन, सो आई डोंट हैव एनी एडिशनल पॉइंट.
just a small uh, my thought on this key. Although NBA is a I mean, that delays the collection of the material, but still I feel कि NBA exemption की जगह अगर if we directly authority helps us, they collect the material, it will be easier in court to prove because they are the government party. If even if we collect it without NBA approval, if let's say that requirement is not there, but still we are doing it. We are talking about another infringement. So other party will say ki they have taken their material only and just so that is not the right approach. If authority does it, then it has value in the court as well for a long-term perspective.
My colleague Rajganesh is the right person to handle this situation.
First, I will deal with Dr. Surya Rao's query and no, no, what you told, sir. Sir, what sir has told was that he has mentioned about the difficulties he faced in enforcing the breeders' right through criminal proceedings. Here, what I would like to submit is breeders' right can be enforced through civil proceedings as well as criminal proceedings. Both are available under the law, and you must resort to criminal proceedings only when you don't know the offender or if he's a fly-by-night operator. If you don't know who with against who is infringing your variety, then in that case alone you have to go for criminal proceedings. And further, sir was saying that he has approached the police station. Again, generally, since all these offences are non-cognizable offences, you have to file a complaint before magistrate, get the order from him to the police to investigate the case, and then after they file the investigation report, then only criminal proceedings will proceed. But still, if you see in deep, criminal proceedings are very weak in nature because the offender can come out very easily. Most are bailable and those things. So most efficient mode of enforcement would be through civil proceedings only. Civil proceedings, why? Because there is a provision under section 66 of relief in infringement suits. You can get an ex parte injunction. So without ordering notice to the other side, you can get an injunction from the court. And another thing is with regard to what Dr. Nitin Joshi sir was saying regarding there is a difficulty in collecting samples. For that, while filing the infringement suit itself, you can make an application to appoint one advocate commissioner. He will go there and seize the samples under the order of the court. Even before us also, many materials have been seized and forwarded and brought to by the advocate commissioner before us for conducting dust test.
It has been
It has been done, and we have did the dust test and submit the report to the court in the sealed cover also. So this is also a possibility is there. And further, another thing I want to say, with effect from 1st April, this 2024 National Biodiversity, this Biological Diversity Act has been amended. And in that, there is a very clear provision that the right granted under PPFR Act is totally exempted from the purview of Biological Diversity Act. Previously also it was there, but now we fought and we made a specific provision and we have inserted it there. And so now it is specifically written in 59A that rights granted under PPFR Act is totally outside the purview of National Biological Diversity Act. So another thing before closing and passing it to Madam, I'll just one thing I like to say to the company people is, see, infringements, once you file an infringement suit, people will turn against you and started perusing your application documents and what are the deficiencies, they will start searching. So my request is file your application in a very particular and correct manner. And next important thing is after registration of the variety, you will also be knowing that you have to pay annual fee to us. And in the annual fee, you are declaring your sales figure. This is very, very important. I want to say to you, the sales figure which you declare in the annual fee return and what you raise in the infringement suit should match. If there is a mismatch, there is a severe risk of your infringement suit getting dismissed, because people will get a certified copy of the annual fee return filed by you, and then they can submit to the court then say that there is a mismatch between the sales figures. And further, I request, if you are filing infringement suit, settle and see that the registration is enforced by settling all annual fee and renewal fee. That's it. Thank you.
Wow, sir, thank you. I think this is a wonderful answer and something that we were looking forward to. Sir, can we have this answer put on the FAQs in the PPVFRA website? Because, see, the purpose of this panel is we will, of course, write down these questions and we will work with you to write down this answer. And if this can come in public domain, it can, stop any doubts any of us have on the problems we face for enforcing PVP on the ground. Dr. Anushri, over to you.
Thing I would like to add that whenever you have, somebody is infringing, you should have very strong evidences in your hand, which is probably sometimes is lacking, because seed and planting material is something which it's very difficult to identify in the market when somebody is selling. How do you identify this is my variety or my seed which has been sold? Just on the basis of the packet, or just if it is open in open market and heap it has been sold. So it's very difficult. So this area is very, very fluid, the the plant variety. I'm sure the
Is there
companies which are facing this problem is a major problem, that how you identify that this person, because see, if you are the a registered breeder, even the person who's infringing your rights will come up with evidences showing that no, I'm not infringing your rights. So it becomes a fight. So that is why it becomes difficult.
Is there a checklist for what will be constituted as evidences?
Yes, that has to be, I think, probably the court or I mean, if it is a provisional protection infringing, which is handled by the authority, I think these checks are very important at the authority level, that one has to check how to identify. And also, apart from, carrying out the dust test, which has been usually carried out to identify the differences between the two varieties, there should be some other special tests to do it in a quicker manner, so that
I think there should be a checklist available in public
yeah.
domain.
So that is very important. I think this is a major problem what people face while having these infringement suits filed. Thank you.
You mean how much was stolen? No, no, it's not about the quantity, because no. The question that Raj Ganesh ji was talking about is sales figures that we are going to take as damages. That part. वो तो बता रहे ना, जाना ही नहीं है पुलिस स्टेशन से। Physical था। हाँ, इसमें तो विचारों का विचार छीन लिए गए ना। बौद्धिक संपदा को।
It's kind of questions that comes up actually.
Well taken, I think.
Seize the homes, exclusion for season of the infringing, seize the infringing variety and as well as preserve it. So these things are available under the civil infringement proceedings itself. So you can resort to that.
And question regarding the presentation we had on the Anti-infringement Bureau. Is there any thing in process or thinking of on that line?
See, at least I am not aware that we have this kind of a thing, but at FSII, I think we've started thinking about, in this direction, about having arbitrators within FSII to resolve disputes if it is within FSII members. Then, so if we can take this beyond FSII, and if we can have the whole seed industry under that, it'll be wonderful. But I think we are a little far behind from what Ignacio talked about. In India, our industry is still at a level where we don't have that maturity to have arbitrators for the whole industry. And again, even if you have arbitrator, उसके बाद भी आप जा सकते हैं civil court में. If you're not happy with the arbitration, you can still go to the civil court. No, so maybe Surya would like.
Yeah,
to
just I want to add to Raj Ganeshan sir. Maybe as Deepak mentioned in the FAQ, or maybe there is sort of documentation where it will be helpful to the registered breeders step by step. For example, as a Syngenta, what we do, first we will send a letter to the particular infringer, because sometimes they may not know that they are infringing. There may be cases just in a good understand good faith. So then the opponent understands that, okay, now they have sent a notice, then we will request them to withdraw that variety. Sometimes they will keep ready for counter us for the second next action. So these are our real-time experiences because we already intimated them. Now they go to the lawyer and then try to build up their case to argue us instead of withdrawing that or maybe coming for the licensing. So these are the cases.
Actually, that's what I'm saying. Under Section 66, subsection 2, there is a specific provision that court can grant ex parte interim injunction. So better you should approach the court directly without giving the cease and desist notice, they say, what you are saying, to stop them from using the infringing variety.
I think, sir,
But before issuing, in plantarity cases, it's better you don't issue that. You directly file and ask for an ex parte interim injunction from the court.
I agree, sir, but with good faith and sometimes.
No, sir, that may be
those
good
are
in
colleagues.
trademark suits or something,
I
but
think
not
it will
in
be a good idea to have a stepwise guide to protect your material on the website of PVP. At least if you have a doubt, what do you do? तो वो अगर स्टेप वाइज रहता है तो it becomes easy for the breeders or for the companies so that they can enforce that. In that case, even educating everybody may not be needed because whoever you need to educate, you have to just guide them to the website कि वहाँ पे लिखा है पढ़ लो, है ना? So that would be a little easier. And I think one thing we have to remember, I think especially for the lawyers, there cannot be two ways of interpreting a law. हाँ, वो दो तरीके से उसको समझाया नहीं जा सकता. आप अगर लॉ में लिखा है कि आपको मोटरसाइकिल चलाते टाइम या स्कूटर चलाते टाइम हेलमेट पहनना है, तो हेलमेट घुटने पे नहीं पहनना, वो सर पे पहनना है. आप घुटने पे पहन के जिरह करोगे कि नहीं साहब हेलमेट पहनना लिखा है, मैंने पहना हेलमेट, घुटने पे पहना है, पुलिस वाला आपकी एक बात नहीं सुनेगा, कहेगा नहीं आपका चालान होगा ही होगा क्योंकि हेलमेट सर पे था. तो the right interpretation of the law is what the cop understands. I think that we should understand. And if I think this third question we can let go of it because I think it's been discussed since the morning. Yes,
Just
Omkar.
one, Nitin just shared that scenario. Something can be still built like PEP also has provision of sharing certificate to the biodiversity authority. Yeah, yeah. So there is a provision, and that sharing is happening. And when a registered person is enforcing his rights against any third party, okay, then some sort of those kind of like you are talking like exemptions or something should be waived off because as the new law also provide clarity. This PVP rights which has been granted it will supersede, and this act itself has overriding effect. Biodiversity have in
I
addition
think
effect. So
I think
something
for
can
that
be
we
used in
will
that direction. Yeah.
we are working toward. I mean, this is one of the parts where PVP and Biodiversity Act, kind of have a contradiction. There are other points also. I think on that we will work with the PVP authority. We will work on those several points, and we will talk about it when we meet NBA.
Yeah, and
So,
just this
of course, for the purpose of this discussion, we are focusing on what Raj Ganesh ji said about the provisions that are available. If these are written in the FAQs, it will become a good endpoint of this discussion also, the one that we are having here, the one that we've had since the morning. So this will be a good addition to the PVP law that we have in India. At least FAQs में सारी चीजें आ सकती हैं.
and that will also create a level of awareness.
Yes,
It's not
yes, of course.
mandated that person should completely follow that, but somebody
Huh.
who doesn't know, at least he can
I think
follow
this is
those
done
things.
in NBA. At least they have some FAQs. They mention FAQs and they mention some of the questions within FAQs. I think we can skip the question number 3 because on gene edited traits we've discussed since the morning, and Dr. Mahapatra already said that there is a committee which is talking about protection of special traits. So maybe this question is answered and we don't have to deliberate on it now. We can go straight away to the fourth question, and this is a really important question. Is it possible to reduce timeline for registration? Because, if you have to wait 4 or 5 years for registration in a vegetable variety, वो 4-5 साल में variety का ही time खत्म हो जाएगा. तो आप फिर उस protection का करोगे क्या? If you moved on to a new variety from the previous one improved version, better version, just imagine if this was happening to the new iPhone. 5 साल में एक आईफोन आता नया, अभी तो हर साल आ रहा है ना. तो if this timeline can be reduced, we've given three examples here. Varieties that are protected elsewhere, maybe under UPOV. Can we consider that protection and reduce the time frame for dust testing in India? Can we use molecular markers? If these varieties are tested under the All India Coordinated Research Project, but they don't make it to the release part, but the testing has been done already, can that data be still considered for protection under PVP? Can the dust data be taken at ACRIP level, at the level of All India Coordinated Research Trials? So these are just three that I listed. Maybe we can have more scenarios like this or more editions. So this time around, let's reverse the flow of information from the other side, from Dr. Anushri onwards.
Um, uh, the first option, varieties protected elsewhere, probably the environmental issues come because if it has been, dust tests conducted outside country and they try to protect here in India, so we cannot probably consider the dust testing under that environment. So therefore, it will be difficult in such cases. Yeah, definitely for molecular markers, already the Act says that we have special tests. So in the varieties where the special tests can provide the identify the dust, the distinct features, I think one can utilize that, but that those guidelines and the tests have to be identified for those particular varieties. So that's my take on it.
I think Dr. Xiang, he from Crop Life, when he was talking about on his presentation, he mentioned um, ePVP, which is a concept in UPOV, where your PVP data can be transported from another country to one country to another country. Um, it's not exactly the same. The problem of environment is still common there also in UPOV, but there is some kind of way that they have figured that if you have a protection somewhere else for the same variety in a different geography, you can reduce some of the parameters and still grant approval quicker. I think that was the idea why we put the first part, protected elsewhere. Um, yes, I think maybe this is going to be a difficult question for.
How they cut down the time.
Sir, actually, now we are working severely on reducing the timelines, and I think probably you will be seeing our plant variety journal. Every issue around for it consists of 1,000 pages and 500, 600 varieties are being advertised, and almost our pendency has been reduced to nearly half. So that is there going on separately. But as far as the issue raised here with regard to the varieties protected elsewhere, unfortunately, we don't have any convention country notified under plant variety protection laws. So registration granted there would not automatically entitle for registration here. They have to apply and then get the registration. And accordingly, even their test report there cannot be taken on record legally here. But still, we are in talks with some countries like Germany, Netherlands. But probably, I think in the long course there will be some positive direction in this regard. And regarding the second, sir, as you told, we have already talked and discovered. Now, my opinion on the third would be that if tested in, sir, as far as this issue also, we are working on merger of VCU and dust testing also, so that the timeline would be reduced. Now we are working on the modalities, how it could be done and what it could be done regarding to the extent notified varieties at the ACRP trial itself. Actually, we taken an agenda in the last authority meeting also, and again we are exploring it further also, sir. Probably we'll come out with some solution. It is under our active consideration, sir.
So the concept under UPOV is purchasing DUS report, what Dr. Prem was telling about ePVP. So and it is more or less limited to European states, 26 European states right now, though other countries can also purchase the reports. But automatic registration is nowhere granted. Automatic registration is nowhere granted. It is the decision of the country that, let's say there is a blueberry which is registered in US, and they want to register in another European state. It is the maybe let's say in Netherlands. So it will be a decision of the Netherlands to purchase the DUS test report from the US PVPA and to grant the protection. So it is because IP rights are territorial, and in most cases, this cross-Atlantic, cross-Pacific, these things are not happening everywhere. So it is this arrangement is only in within the European Union, right? And the second is use of molecular markers, as my colleague Raj Ganesh has said. Yes, we are thinking over it, and let's see. It's a work we have just started uh, discussing in what form which molecular markers can be used for augmenting DOS test. One way of doing it, what South Korea does, is that they have a fingerprint database for all the registered varieties, and whenever there is a new material come, they check these fingerprints. But that is my question. That is one of the approach that they are doing. And the third, if tested in the AICRP, but then this is uh, it's a very vague question. Sorry, because the AICRP test only VCU for value for cultivation and use. And if you go technically, they do not do any dust testing.
उसमें कर सकते हैं दादा dust?
We in 2012 initiated this exercise, and we discussed probably a lot of people here. You may not be there, but maybe Surya Rao knows. We discussed this with all the project coordinators. So at that moment of time, the project coordinator said it is practically impossible right now. I give you an example. So 24 to 26, there was a rice AGM this year, here only. So last year there were 78 varieties were released, including varieties and hybrids. And this year I think 51 plus another 68 varieties will be has already been promoted for notification. So what they said is that even in Europe, this VCU and DUS are conducted for national listing, but they're conducted by two separate trials, not in the same trial, because the parameters of AICRP and the parameters of DUS are different over there, are different over here. I'm not going into detail. So if we can do, well and good, but right now probably it is not feasible, right now.
Okay, any comments from the audience? You seem to be very silent. Yes, Dr. Saab.
The SAN knows it very well.
एक मिनट सर माइक दे रहे हैं आपको वो आ गए पीछे से
About the first one, what Raj Ganesh was mentioning about the convention countries, I know the discussions are going on with Netherlands and Germany for the last 3-4 years. Suppose it materializes, would we have this reciprocal rights of registration?
Yes, sir. If it materializes and then we enter into an agreement and then later it will be notified in the official gazette as a convention country, then definitely there will be a reciprocal recognition of registration.
वो भी सर मेरी समझ ये है कि वो शायद क्रॉप स्पेसिफिक होगा है ना नॉट फॉर ऑल क्रॉप्स मे बी फॉर स्पेसिफिक
Yes, sir. Actually, in the MOU which we will enter into between the not MOU, the treaty which we enter into between the countries, the crops, the Jondran species will be specifically provided. Both the countries has to provide in that Jondran species. Then
But,
only.
are there any problems there?
Sir, problems is only one thing that our law that is not incompatible with UPO because we provide for farmers' rights and extent varieties which is not in their law.
Yeah.
But still we are working out modalities.
That's true.
for it.
I think, sir, one thing is, I mean, I was also in the APSA conference where Raghavan was there. And I was thinking that we are not the only one with sui generis system for plant variety protection. एशिया में ज्यादातर कंट्रीज के पास सुई जेनेरी सिस्टम ही है तो हम अपना आईपॉप वगैरह क्यों नहीं बना सकते कोई ऊपोव के जैसा मतलब एटलीस्ट हम उनके साथ मिलके ही कोई साठगांठ
So
कर लें
there is a sui generis is a conundrum. Every IP law is a sui generis system. Every IP law. I give you an example. US PVPA, plant variety protection, till 2020 they do not give protection for asexually reproduced crop. Do you know that? They only give protection for seed and tuber propagated crop. In 2018, there was a farm bill which was passed by the Senate and the Congress, and then in 2020 they put up the rules and regulations. From 1970, they acceded to 1961, 78, and 91 convention. Till 2020, they did not give any protection for asexually reproduced crop. So what is that? That is also a sui generis system for them. Right now, they are fully compliant with what UPOP does for all crops. Right. So every IP on the plant variety is a separate system on their own and maybe a sui generis system.
Thank you, Dada. I think if we don't have, yes, please. Can you give the mic to the gentleman?
What? What? EPIA.
Different. The ministries are different.
Ministry, no. This PVP comes under Ministry of Agriculture. All IPR comes under DPIA.
I know, sir. So what if it is comes under DPIT? How the
Sir, that we cannot decide at our level. It has to be decided by Prime Minister.
So it is
But it's a good suggestion.
I'm
Good
asking
suggestion.
what if
Australia, they all come under IP Australia.
so what if it comes under this DPIT, or what would be the challenges and how the challenges can be reduced?
I think ये first question वाला challenge resolve हो जाएगा because then patent PVP उसमें अच्छे से difference पता लग जाएगा if it is है ना. At least वो first question के लिए this will be, but I think it's beyond it's beyond our pay level to discuss whether ministry change हो सकती है कि नहीं. I think this is
Just one submission. Sometime we feel centralization is good. Let's come everything under one umbrella. But this also gives us sometime problem. Okay,
yeah.
because many things like seed things are also in DGFT. Then we also have a feeling whether they understand that part as well. So sometimes like idea is good, but sometimes things is running well. Let us continue well, unless we find very much merit
I
in
think this is the difference between this intellectual property right itself. From the morning, you probably heard about it. This IPR is highly technical in the sense, there's no easy way of explaining a EDV to anybody. Maybe essentially derived variety वो या EDV छोटा बना के हमने बोल दिया तो आसानी से समझ आ जाता है. But if I say that the same thing is actually a near isogenic line, आपको मुझे वो ब्रीडिंग के 3 साल की पढ़ाई करानी पड़ेगी नियर आइसोजेनिक लाइन समझाने के लिए. तो ये इतनी टेक्निकल चीज है. एंड वैसे एज मच एज आई अंडरस्टैंड द लॉ, the parliament enacted this law so that this authority becomes a quasi legal body. The PPV FRA is a quasi legal body, but their mother ministry is Ministry of Agriculture. They sit under that ministry, but they are a sui generis system in themselves. मतलब वो autonomous body है PPVFR है. Statutory body. It's a statutory body. So I don't think it will come under the centralized ministry.
No, TIPPT is what you're talking about is under Ministry of Commerce and Industry. So it will not be put Ministry of Agriculture. Two ministries cannot merge.
Yes.
So this question is regarding the EDV actually. In some plant varieties where the mutations occur naturally, in such cases, if such kind of mutation happens, will it be considered under EDV? Because we do not have any mutant guideline.
Answer to your question is yes and might be. So if you see the section 2J, the definition of an EDV, it says that a variety should be predominantly derived from an initial variety. That is one thing. The second, it conforms to all the essential characters of the initial variety. And then third is that it should be clearly distinguishable from the initial variety. So if a mutant satisfies all these three, then it can be an EDV as well. Is that answer okay? Right.
I think with this, we still have, okay, I think Nitin and Surya still have some points left. So Nitin, over to you.
Beyond four? No, it's the fourth one which we started from that side, na? So, and then you are. That's right. So, no. So, like the PPV FRA authority people, both Raj Ganesh ji and Dr. Deepal Chaudhary had said that these three possibilities are right now, as per the act, it's not possible. So, there right now it's not there. So maybe the molecular markers, maybe the future option. And I'm taking their guidance also for the last 15 years doing the PVP registration. So I won't talk about these three. I have a fourth point. The fourth point is like we have the registration happening in 4 or 5 years. But let's say now the process is also more streamlined now. We submit everything, the application and seed material. Earlier, applicants were also not giving seed at that time. So there was a delay from our side also. But now the fees, everything is coming at that together. And it is going for the dust testing. So, sir, I think because they are also sending just for the understanding of the students, so they are sending the seed material for dust testing sites which are under the state agriculture universities or ICR institutes. So it's taking time, the data coming from them and analyzing them. So, sir, it can be more streamlined if you, sir, incentivize. Let's say, like you always write a letter of query, respond in 15 days. Similarly, if you give letters to the those SAUs to submit their DUS reports data in 1 month or 2 months, something like that. And if you do that, we will give you 100% money. If you further delay 1 month, then 90%, something a kind of a incentivization, and so that the reports comes on time. So I see, the registration will happen. My calculation, it will be somewhere around 3 years. We will have the registration, and by the time normally what happens in the hybrid, it's the third year when your hybrid sale is on the peak. So by the time there will be a kind of when infringement possibilities are on a higher side. At the same time, we will have the registration in place. So that's a request.
That's a good point. Patents have this.
Yeah.
We have the examination, that is, once the application for patent is filed, then there's a request for examination and there's a deadline for it. So, similarly, for examination, when you give the seed and you pay the fee for the dust test, there should be a deadline. So, if that deadline goes off, the application gets abandoned. So some kind of detrimental should be, there's a deadline issue happens, and therefore maybe in the rules you can have this change for the putting up this kind of a timeline. If that timeline comes up, I think that will help in reducing the time
What is
for
original
registration.
point? Sending the seed for dust testing. That's on.
No, so is also in the Patent Act. Once the RFE, request for examination, is filed, there is a chronological order which the patent office follows, and then even the examiners have a timeline. Then once the application come to them for examination, within 2 months they have to take it out from their table, for after examination and put forward for and releasing the examination report. So that's given in the rules. So some similar kind of, if you want both sides to have a timeline,
Right.
that can happen.
And one more point, sir. When if we get the registration on time, we will start paying. So ultimately, you will get more because now what's happening? Our hybrid is out of the market. We get the registration, so it's only 2,000 as annual fee. But if it is on time, then you will calculate 0.1% of the sale value. It will be coming in lakhs also. So you can increase your manpower. Also, give back to SEUs.
I think to add to the point, Nitin, if the provisional protection is strong enough, if that also becomes stronger, then also we will have this benefit when you actually start selling the variety. For provisional protection, Dr. Mahapatra, I think, mentioned that we have a committee which is working on making the rules and the protocol for how provisional protection will work. I and Dr. Anushri are part of that committee. Mr. Raj Ganesh is also a part of that committee. So committee के 3 लोग तो यहीं बैठे हैं. तो हम definitely डॉक्टर गुप्ता चेयरमैन थे अभी थोड़ी देर पहले गए. तो हम लोग एक मीटिंग हमारी हो चुकी है और हमें डेडलाइन दे दी गई है कि 3 से 4 महीने में आपने एक पुख्ता प्रोटोकॉल लेके सामने आना है. So we are working on that. Just like the last question, 3 points, it is work in progress. So at least that will also address some part of this problem where, you know, where you actually go commercial, then there should be some form of protection. I'll give you an example from Australia. वहाँ पे provisional protection is still also considered weaker than actual protection. But what additionally you can get in provisional protection is that you can use the PBR logo on your seed packet and say provisionally protected under PBR law, plant breeder right law. तो वो है वैसा है जैसा आप किसी भी कमोडिटी के पीछे लिख देते हो ना पेटेंट पेंडिंग, तो वो पेटेंट पेंडिंग के जैसा है. इट्स लाइक अ डेटरेंट so that copy na ho. So deterrent is I think even the protection itself is more of a deterrent. You know, वो मतलब ताले चोर के लिए नहीं लगाए जाते वो ईमानदार लोगों के लिए लगाए जाते ताकि वो आजमाइश में ना पड़े ना, वो they don't get into temptation. I think maybe Surya still has some points.
No, if you allow that, I would say. Point number 3, I want to make one point, Dipal sir. Now the gene editing technology is already within the research institutions, and then we are making varieties. But the definition of EDV, as long as essential characters are retaining, and then if there are any non-essential character changes, then it can be an EDV. If my understanding is correct, the definition of EDV. So in gene editing, we can do the even essential character also. Then can it be a EDV? Through gene editing, if I can change the essential character also, why can't it should be a EDV? Because everything is same.
This is one of the questions that we are dealing with this EDV committee.
Okay, thank you, sir. So coming back to the 4 point, I think we already had a primary discussion about this thing. Sir, the why we raised this question, it is not that we are asking you to directly accept what is already registered elsewhere and then give the certificate here. What we are saying, there the authority is already verified the dust characters. May not be every character will be performed here, but essential characters should not be changed. Whether you do in Australia or US, or those are common. So for 1 year,
if you have a working proposal, which you think suits Indian perspective, why don't you propose it? Let's say we are open to it. We didn't say that it cannot be happened.
Yeah, because
let's see. As of now, we are not under any convention, as Mr. Rajganesh has already said. But let's see. Similarly, in AICRP also, the doors are not closed. If the AICRP can conduct the DUS test and certify the results, of course, this can be what Rajganesh has said. March VCU and DUS, if they do, in Europe they does.
Yeah.
The industry also has to come to terms with VCU first because it's a competitive assessment of your variety against another variety and you risk failure.
Sir, I'm surprising for the point number 4, as point number 4C. But as you rightly mentioned, if the VC is not taking the dust characters, then how the authority is granting directly the registration for the notified varieties?
This is
because we are considering somewhere we are considering those things.
See, what happens is that the application, the dust rates, the release proposal, they do have dust rate which is generated by the
now
applicant.
we are asking dust characters as part
so
of that.
applicant. So that application has dust characters, but actually the DUS testing is slightly different from dust characterization. You must be knowing what is DUS test. So you give an application where, let's say in maize there are 31, 32 characters are there. In rice there are 62 characters are there. So you describe that, you identify a reference variety, suitable reference variety, you constitute a trial, and they may be grown side by side. This is not happening in the VCU trial. In the VCU trial, the perspective is that you should have a 5 to 10% yield advantage of the best material or check. Whereas in DUS, we have what? That it has to have a distinct trait which is different, clearly distinguishable from the suitable reference variety. So these two things are two different things.
I agree, sir. So continuation of that, sorry, Deepak. Right now, I think you already mentioned that discussions are started with ICAR or maybe the ACRIP centers to consider this point. The point what where sometimes there are hybrids, you know that, sir. They complete all the 3 years of testing, but whatever the reasons is finally don't go through the registration, the notification. So, but once it is fulfilling all the characters, means testing and everything, maybe 1 year of the test data recorded there can be considered instead of 2 years again going here for the test testing. Because fast track, these are some suggestions to fast track.
I think it's been a healthy discussion, and we've gone past our 1 hour. Thank you, ladies and gentlemen, for being so patient with us. I hope you have a pleasant evening. Thanks a lot.
Thank you so much. Before we wrap our sessions today, I have a gentle request to make. There's a QR code right on your tables. If you could kindly scan them and give your feedback, it will be helpful for us to understand, to get your feedback and to improve and tailor future events and conferences that we do at FSII. For the vote of thanks, I would like to request Mr. Kuldeep Tyagi from FSII. Uh, okay.
Thank you all the speakers on the dais. Dr. Chaudhary, Mr. Raj Ganesh, Nitin, Deepak, Dr. Gupta. And I would like to thank the partners, National Law University and PPFRA, for all your help and support. Um, and we received a very overwhelming support participation from the stakeholders. Um, we saw lawyers, students, authorities, members from industry participating here. And we understand from today's discussion that the seed technology is evolving, and so are the challenges, with regards to protecting this technology. And then there is more awareness that is required in the industry, the government people, the law enforcement authorities. So this is the first interaction get together that we have done. There will be many more we will do in different cities. And engaging with more people, state governments, central government as well. So with this, I thank you all. Thank you all for joining us.
There is tea and some cookies arranged for you. Yes. Thank you so much. Give me that.